Welcome to the March the 10th convening of the Baltimore City Board of Municipal and Zoning Appeals. A few house rules first before we get underway. You'll note that there are a number of microphones arrayed around us up here. Those microphones are all very sensitive. They're not only for the purpose of amplification, but also for the purpose of recording these proceedings. Additionally, those of you who are forward of the wall, if you look behind you, can see that there are 3 video cameras mounted on the wall behind you, and there are 2 video cameras mounted on the walls up here behind us. And those video cameras are active and rolling and recording these proceedings for broadcast on the city's cable access network. Telephone calls, cell phones ringing, pagers going off, anything basically that makes any kind of an audible electronic sound are generally disruptive to these proceedings, and for that reason we ask that at a minimum they be turned to a vibrate-only position if not off. Additionally, to the extent that you need to have a telephone conversation, you need to have a conversation with someone who's seated next to you, or maybe not seated quite so next to you, we ask that you at a minimum take that, that discussion out the double doors to the rear, as conversations in the gallery not only disrupt the general conduct of these proceedings, but also are disruptive of the recording of the proceedings. The procedure for today is we're going to be voting at the end of the day. You're certainly more than welcome to sit around and enjoy a civics lesson if you so choose, although our docket's not quite as long as it typically is today. But if you've got other things to do this afternoon, you can call into the zoning board office and find out how we ruled. You take out pen and paper. I can give you the number for the zoning board office. That number is 410-396-4301. Again, 410-396-4301. You will, however, need to wait until you receive the formal written outcome of your case. That should be forthcoming in about 3 to 4 weeks. We certainly ask that you not build in the city of Baltimore without first obtaining proper permits. If not already done so, if you're here in opposition to any case, we ask that you sign in on our sign-in sheet, held up by Mr. French there. The purpose of that allows us to not only know generally which cases have opposition, but also allows us to know who needs to receive those aforementioned written notices I referred to earlier. So if you haven't done so already, please sign in on the sign-in sheet. The procedure for when cases are called, if you're the appellant, you'll come forward and stand to our left or your right. The opposition, if any, will stand to our right or your left. Once everyone is up here, we'll get you sworn in, and the appellant will be given the chance to proceed first and present their side of things, let us know what the issues are, what's being presented, present any testimony from witnesses, and respond to any questions from the board. Once they're done with their presentation, we'll then turn to the opposition, who will be given the opportunity to present their side of things. Once the opposition is concluded, we'll be returning back to the appellant to respond to any points that were brought up by their opposition and to offer a closing statement. We won't be going back and forth, unnecessarily delaying the proceedings. We will generally be calling the cases in the order in which they appear on the docket. However, we have a couple of cases that are a little bit larger and have a few more issues, so we're going to jump around a little bit to get the folks who are here on some more discrete matters out of here so that you folks can go about your day. Since we have no cases that are on the consent agenda or which are being postponed, we'll proceed with our docket. The first case we'll hear today is 2014-536, 3423-40 through 49 Noble Street, Surun Che.
Good morning.
Afternoon.
I slid down my driveway. Does the board have this presentation? I thought it was given to you at an earlier time.
You can pass it up, Mike.
I I'm sorry, we have a little bit of a critical problem. The senior man in Conaway Commercial Real Estate, Howard Conaway, died suddenly 3 weeks ago. And,
Okay.
all of the files and including and all of the computers, including my computer, disappeared. My name is Anthony L. Brennan, B-R-E-N-N-A-N. I was house counsel and a 40-year friend of Howard's.
All right.
And also a friend of Peter Farakis, whose company owns this property.
Okay, well, we'll see.
I think we're here only to determine, we did have a meeting with the community, and I believe they have addressed a letter to you, have they not?
I think so, but first we can, yes. Are you, what's your name, ma'am?
Rachel Timmons?
Okay, and Ms. Timmons, are you for or against what's being proposed?
Oh, I'm for them. We did submit a signed MOU to you all.
Okay, all right. And Mr. Brennan, we have this as an application to use the entire premises as a laundromat with accessory food service, is that correct?
That's correct.
Okay. Can we have all those who are going to be giving testimony raise their hands and be sworn?
Do solemnly swear or affirm under the penalties of perjury that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. And do we first
We've
have...
had a previous hearing on this.
Okay. Do we have staff reports?
Yes. First, we have a letter from the Baltimore Highlands Neighborhood Association. It essentially is functioning as the MOU. It goes on to list 6 conditions. That the appellant and their legal representatives agree that the laundromat and food service will provide and maintain exterior and interior trash cans. That the appellant and their legal representative agree that the laundromat and food service will provide and maintain exterior and interior security cameras for the business location. That the appellant and their legal representatives agree that the laundromat and food service will not operate past 12 midnight on any day of the week. That the appellant and their legal representative agree that if the laundromat and food services decides to include massage chairs in this business location, that these massage chairs will be kept in an area of the building where they can easily be seen by the public, not in a hidden back room. That the appellant and their legal representatives agree that the laundromat and food service business will accept cash and credit cards. That the appellant and their legal representative agree that the laundromat and food service will provide substantial exterior dusk to dawn lighting. I think there's one more. And that the appellant and their legal representative also make themselves available to meet with the association within 7 business days of such a request from the association. And this document has been signed by Mr. Shun Chi. Am I correct?
Yes, he is the,
Okay.
he is the, going to be developing the property, buying the property. And he's right here on the right.
I thought we had a letter from Craig. Okay. And we have a letter from Councilman Kraft indicating that he is in support of the association and planning's report.
Thank you. Martin French for the Baltimore City Planning Department. Planning Department notes that this property is currently in a non-conforming use status in the R8 zoning district. However, the department notes that this service that is being proposed by the applicant appears to be something that is needed in the area and therefore has no objection to this appeal. Thank you.
Thank you. Okay, and Mr. Brennan, was the agreement that was read into the record, is that your understanding of the agreement that's been reached between the parties?
So you have to do.
Okay. And ma'am, your name again was?
Rachel Timmons?
Okay, and Ms. Timmons, that agreement that was read into the record, that's the agreement that was proposed by the Community Association?
Yes.
Okay. And there weren't any other terms or anything like that, any other further agreements or?
Nope.
Okay, all right. We will incorporate that agreement into whatever order we generate if the request is granted. And Mr. Brennan, if you want to briefly describe what the proposed use here is going to be and how the operation is going to
Proposed
function.
use will be a laundromat, a spacious, well-lighted laundromat. It will have a food service adjacent to it. It will serve the community much better than many of those that are existing in the area. It will be lighted, well-lighted, well cared for, and kept clean.
The food service portion of the operation, that's going to be limited to those, I guess, the patrons of the laundromat?
That's correct.
All right. As I look at the drawing here, it's a little bit hard to understand, but as I understand it here, there's would appear to be 4 or 5 tables here, and then the is this a counter that people are going to be ordering from?
Yeah.
Okay. And will it be that the customers will go up to the counter, make their orders, take it, and only be able to eat the food here in the seated area?
Yes, they could consume the food there, or mainly that's the eating area.
Okay.
So then they could have a place to sit down and consume their food.
All right. And the food service portion is going to have same hours as the laundromat, I presume?
Either the same hours or less, because it's probably might close early or the same hours.
Okay. All right.
I'm sorry, I did not bring more copies of this, but we.
I think you described the difficulties you're operating under.
Almost ex-wife walked away with all the files, the computers, took my computer too, which I squawked about and got back. But it has not been a pleasant time. But we're, for Peter's sake and Peter Baracus' sake,
Mr. Chia.
Mr. Chia, we're here. This is Charles Upton, who's also with the company, and he's been helpful trying to keep things alive and well for us.
Okay.
I really have no summary except to say I think it'll be an excellent use in the community, and
Well, I know that there have been some challenges with proposed uses at this location before, and so, you know, we definitely take note of the support of the community association with this, and it sounds like you all were able to reach a fairly expansive agreement. And your, the plans that you forwarded, can we make these a copy of?
Oh,
can
certainly.
we
You may do
include
as
these in
you
the
wish.
record, or do you need those back? Or?
I can send it to you via email if you like, the color pictures and all.
Okay, we can do that.
Yeah.
What is your email?
Charles Upton, UPTLN.
You can forward the plans to Mr. Tanner, and then we'll incorporate those into our record.
I'm sorry we are not as prepared as we could be, but it's taken a little while.
I can actually do it from here. I can do it from my phone. If you
Oh, okay, that's perfect.
I'll
I'm
do
not
that.
too sure that we can receive it from here, but that's fine.
But I'll send it, okay,
All right.
before I leave.
Okay, was any further questions? All right, thank you all.
Thank you very much.
Thank you.
Are you a member of the
All right, calling next case 2015-35, 1003, 1005, and 1007 South Belnord Avenue, AB Associates, care of Nate Prettle. Afternoon, Mr. Prettle.
Good afternoon.
We have this as an application to raise and consolidate lots, subdivide into 2 lots and construct 2 new 4-story attached single-family dwellings with rear decks, rooftop decks, and front accessed garages. Is that correct?
That's essentially correct.
Okay, we can
Yeah.
clarify that a little bit. And ma'am, your name for the record?
Good afternoon, Lauren Seldenridge.
Okay.
1001 and a half South Belmore, which is next door, and I'm not opposing on the opposing side.
Okay. All right. If all those giving testimony can raise their hands and be sworn, please.
Do you solemnly swear or affirm under the penalties of perjury that the testimony you give will be the truth, whole truth, nothing but the truth, so help you God?
Yes.
Okay. Do we have staff reports?
We have one report from planning. Thank you. Planning Department noted this is essentially a proposal to consolidate 3 lots and replace 3 lots with 2 lots. The existing use of the property is single-family housing. The replacement use of the property would likewise be single-family housing, only 2 units instead of 3. The department therefore notes that there would be certain variances required in association with this. However, the department recommends approval of this appeal, if granted, be subject to the condition that subdivision of the lot that would be created by consolidation of the 3 existing properties be approved by the Planning Commission. Thank you.
Thank you. And Mr. Prettle, those conditions stated by the planning department amenable to your client?
Yes, they are.
Okay. Now you indicated that there was, I guess, some discrepancy maybe in the description. So if you can kind of go through what's being proposed, we can sort of flesh that out.
So a little bit of background. This is similar to a proposal that was approved by this board, I believe in November, December of last year, which was to construct the 2nd floor and then 3rd and 4th floor or penthouse additions of the 3 existing properties. My client at the time was the contract purchaser. Since that approval, they are now the owner. When they got into the building, they realized that there were some site and structural issues that may not have allowed them to renovate and build onto the existing buildings as proposed. So we sought this revised plan that would completely demolish the buildings, create 2 larger buildings, which would in fact work better than we had before. They'd have larger garages that would probably work better, and so that's where we are right now. I don't know if you want me to get into the whole proposal and variance standards, or if you just wanted to clarify the discrepancy in what you read in the beginning. I can go through the whole thing, but that may not be necessary.
I'm not sure that it is.
I would just add, if you have the brief version, that this the scale and massing of this is almost identical to what was approved before, except slightly reduced. The 4th floor is 25% of the roof area, which was a concern of the board. We originally it was proposed as a full 4th floor. Now we look at it as a penthouse rather than a 4th floor, and this meets the same 25% as before. We're actually providing 9 foot of additional view corridor that wasn't in the original plan. The properties combined are 40 feet wide. There was approximately 32 of those feet were covered by a 4th floor in the original plan. This plan covers 23 feet. That's an increase of 23% open space for the neighbors. That wasn't a concern for a neighbor who showed up last time. And the variance we're asking for in terms of rear yard setback has been reduced as well. We were asking for a 3-foot rear yard setback in the original plan. Here we've increased that to a 9-foot rear yard setback. Those are the primary differences. Otherwise, the scale of the building is almost identical to what was previously approved. And it's a less dense project, 3 units versus 2 units.
Okay. I did note that there's, in the rooftop penthouse, there's an indication of a plumbing fixture there. Looks like it's a sink.
Correct.
And do sinks qualify as?
Well, first, we're in a
living space?
B1-2 district, not the R8, so that's
All right.
that's the difference. If
Good point.
we had other people, we would have been willing to limit this to roof access only. I don't see any opposition here, so I think we'd rather stick with the plans that were submitted.
All right.
He's still a representative of what was approved last time.
Okay. Any questions? All right. Ma'am, was there anything that you wanted to offer?
No, I really have nothing to add. I can check with them with the actual development project rather than the zoning issues, and I've been in contact with the company and talked to them extensively about their plans once they get started. And
Okay.
they've been very helpful.
All right, great. Anything further?
No.
All right. Thank you very much.
Great, thank you.
Thank you.
Okay. I think that gets rid of the easy part of the docket, or easier part of the docket anyway. All right. Call next, 2014-64, 3600 Clipper Mill Road. And we'll call with that 2015-25, which is also 3600 Clipper Mill Road. Nonsense. Okay, and we've got Ms. Byrne and Mr. Veal making their way up. You're part of the party too. Please come forward. Well, if you want to take some issues away from us, we're always ears for that. Okay. So, as I understand these matters, we've got two appeals that are consolidated here involving the same property. This initially began as an appeal last year between the parties at that time were Clear Channel and Himmerich Associates. There subsequently was a revocation of a building permit that was issued, and the property owner, that is Himmerich, appealed that, and that's when the city became involved, the zoning administrator's office. And I'm trying to figure out which sequence to hear this in. My initial inclination was to just simply hear it in the sequence in which the issues kind of percolated up to us. Though I didn't know, Ms. Byrne, if you had any kind of input on that.
From the city's perspective, we're here on the narrow issue on the revocation. And we can have a chicken and an egg conversation all day long on this. That the permit was issued, the billboard was erected, issues were found with the billboard that caused the city to revoke the permit. Then there was the part 2 of converting the existing billboard to an LED billboard, which is what the owner had applied for. But technically, there's no legal permit on the property today. So the billboard that exists that permit was revoked. So I think it might be easier to deal with the revocation. Did the city properly revoke the permit first? And the board can tell us, did we do it right or not? And depending on the answer for that, can move to other issues. That would be my input, but it's up to the board.
Okay. And I mean, I understand it. The only direct bearing that the revocation issue would have on the other dispute is around any issue of abandonment, and I understand that you don't really have a position one way or the other on that.
We don't. It would be up to the board. So, like, the reason why we revoked the permit, and this was in the summary of what we submitted, is that the original billboard was 75 feet. We accepted the documentation from the applicant, and it said 65 feet. It wasn't until after the new billboard was erected that we discovered the error, that as a replacement in kind, it needed to be 75 feet, not 65 feet. The building official doesn't have the authority to issue a permit for something different when it's a non-conforming general advertising sign. Only the board can say that, yes, it can be 65 feet and not 75 feet. So that was the basis, that was one basis for the revocation of the permit, was the discrepancy in the height. So whether or not the non-conforming use continues, it's up to the board. So the board has to make a decision, you know, did we revoke it properly based on that grounds? 2, what happens next?
Okay. All right. Council, did you have anything that you wanted to be heard on as far as the sequence?
I'm sorry, Mr. Chair. I'm sorry to talk about Enterprise.
That's fine.
LLC. Thank you, Mr. Elmore.
Sorry.
In our position with respect to the revocation is irrelevant. That at the end of the day, first of all, it shouldn't have been revoked because what we are seeking to do is, what we did was decrease the sign, which is allowed by 11502 and 11506. Which is allowed by 11502 and 11506, and in addition to that, the fact of the matter is that the original approval for by the BMZA 24999X said that the limit of the billboard was up to 75 feet. So here we are reducing 65 feet, and I'm not sure. And 11502 and 11506 allow decreases, don't allow increases. So that the issue, frankly, appears to be irrelevant. If the board approves the relief we seek today, that is that the 65-foot sign is in accordance with what has been approved previously, and in addition it approves the LED aspects of the sign, then the whole issue goes away and becomes irrelevant. So to the extent that there's a revocation and it's deemed to have any impact, we suggest that the board find that the revocation was not proper, or that it's irrelevant and has no impact as to the ultimate relief we seek here today.
And Mr. Woolman.
Again, for the record, Joseph Woolman on behalf of Clear Channel, Mr. Chairman, members of the board. The first point I would make is, as Ms. Byrne just pointed out, the height is just but one issue related to the revocation. There were additional issues, and I think her submissions to the board indicated there were additional issues to the height. But that being said, and this speaks more to the procedural question you had, Mr. Chairman, we have a preliminary motion to dismiss the matter, which probably should be heard before the substance of the appeal. Obviously, it's up to the board whether they want to hear from the city regarding the revocation before we're heard on the motion to dismiss. But I have to say, in response to Mr. Scher, that I still can't for the life of me figure out how this can go forward when you had a billboard that was applied to be changed back in February of last year that was later torn down without the owner of that billboard's permission. And then another billboard was put up, and that permit for that billboard is revoked. And as Ms. Byrne just said, today there is no legal billboard on that site. I don't know why we're going forward.
The fact that CCO asserts that they own the billboard is fanciful at best. The non-conforming use is owned by the property owner, and I think all the legal cases and the law that even proffered by this board in the North Howard Street case make it clear that the property owner owns a non-conforming use. There's no ownership by CCO. Its ownership or interest in the property ceased at the time that it failed to renew its lease and the lease was terminated. But in addition to that, preliminary motion that we have is that we believe CCO has no standing to be here today and should not be participating in this proceeding. That it's here for the sole reason that it's anti-competitive. It wants to prohibit and reached up from the grave to prohibit our client from utilizing its property for billboard purposes, and it has no standing to do that because the only interest it has in this matter is the interest of being non-competitive. It has no interest in the property itself. And being non-competitive, that being its sole interest, the cases are clear that that's not a grounds for standing to participate in an appeal.
All right. I think I'm going to stick with my initial inclination, which was to hear the issues and time, I guess, in the time sequence in which they reached us. So, Ms. Byrne and Mr. Veal, you guys can have a seat. And once we're done with this portion, then we'll get to your portion.
Well, there is the preliminary motion. If you find that CCO has standing, there is a preliminary motion of a motion to dismiss.
Yes.
Should we be heard on that first? Or?
Yes. So we're going to hear the issues involved in appeal number 2014-64. And I think that that's where your preliminary issues arise from. And then as far as the second appeal, as I understand that, that's relating to, and that is 2015-25. The issues involved in that appeal, I understand as relating to the issues surrounding the revocation of the permit. So we'll hear the issues involved in 2014-64 first, and then we'll move on to the revocation issues.
And in that context, would you like to hear from us on the motions to dismiss?
Yes.
So I have moved that CCO has no standing here today, and that it be prohibited
Well,
from
I think that the
proceeding.
first motion, going back in time, I believe, was Mr. Woolman's. The issue, I guess the motion to dismiss regarding whether or not Utah Place is the owner and has standing to proceed, or whether the non-conforming use belongs to Clear Channel, and therefore they should be the only ones who control what happens with the conditional use.
I'm not sure I quite understand. If CCO has no standing to be here today, then they have no standing to argue that there's a motion to dismiss anything.
Well, I think that he filed his motion first.
Okay.
So I think that he gets to go first.
Take over the vote here.
But as I see it, I think that the issues are interlinked. All right, Mr. Woolman.
Thank you, Mr. Chairman, members of the board. Again, I'm tempted to go right to my closing argument on this because, again, I can't for the life of me figure out how we go forward. I would just quickly state in response to the recent statement by Mr. Scher that we're not talking about the ownership of the billboard that's out there now. We're talking about the ownership of the billboard that this appellant applied to this board to change. And there's no dispute that Clear Channel owned the billboard back in February when the appellant filed to change that billboard. That billboard's gone now, and there's nothing out there that's legal. So with that being said, I understand you're not going to rule now. I'd like to be heard regarding our motion. I'd like to call Mr. Joe King from Clear Channel as a witness in the matter.
All right. Although you're yeah, as I understood your motion, that was, well, you can present your record.
Thank you. And just by way of explanation, and we've stated this all along, Clear Channel applies to this board to convert static billboards to digital all the time. I think there's been over 20 of them. If this case does get that far, we don't have a whole lot of argument, if any, regarding a conversion of a static billboard to digital. It's the business Clear Channel's in. They don't oppose the idea of converting a billboard to digital. The testimony I plan to elicit from Mr. King speaks to the motion to dismiss and all the issues that raises, including some issues regarding the revocation for that matter.
Okay, and as I was going through it, the thing that sort of struck me as at the heart of this, I think that this comes out in the first page of your motion, when you talk about the language of 14-201, which is the application process for a conditional use, and you quote the language that an application for conditional use must be filed by the property owner or with the written consent of the property owner. And your argument, as I understand it, is that the property owner there refers to the owner of the actual sign. And as I understand Utah's position, that language refers to the real property owner. And I think that the sort of dispositive issue that's presented is what's intended by this language. Does it refer to the real property owner, or does it refer to the personal property owner? If we concluded that it referred to the real property owner and not the personal property owner, would you see that as being dispositive of the question?
Not the entire question, no, but I understand the chairman's point. I think that there's some unique characteristics related to the use of a billboard structure and the structure itself, and I get into that further in the memorandum, as I'm sure you've noticed, that there certainly are some unique characteristics. I cited a case from the Court of Special Appeals that expands upon that theory regarding use. So even if the board said that that language refers to a real property owner or a landowner, if you will, I don't think that language can be interpreted to apply to this situation because of the unique characteristics that surround the outdoor advertising use. The structure itself is the use. I think the only other thing I can think of that would be analogous would maybe be a cell tower on top of the building, and I think there's some interesting issues at play here that's going to have an effect on the precedent set regarding that business as well.
Well, I
So-
think that I know that our typical procedure with those, and I think it follows through with other cases as well, is that those cases we look to that the case has to be filed with the either by or with the consent of the real property owner, and that's typically a threshold that that's easily addressed in those cell phone cases. And the thing that kind of jumps out at me at this case is thinking about it conceptually, is that zoning is really the power to zone comes from the government's power to regulate uses of land. And here you're saying that the power isn't to regulate the land itself, it's just more narrow than that, it's just only applied to the use, such that the government could, taken to its extent, could you have a case where the case is filed without the permission of or consent of the property owner, but that is the real property owner, but there's approval granted by this board for the personal property owner, authorizing that use to be made of the real property owner's property, even though the real property owner may object to it.
I understand what the chairman is saying. I think the reverse also holds true. In this situation, you have the owner of the real property without the knowledge or consent of the owner of the trade fixture, I would argue, which is an important distinction, the trade fixture of the billboard itself, filing without any consent or knowledge of the owner of that property. Again, I think it speaks to the unique characteristics, and if the board looks at its own history as to how it accepts and handles applications for digital conversions, and we're going to be introducing several examples of that, obviously, onto the record, I think it's clear that the board has always taken the position that it is the billboard company that applies and is the applicant to change these billboards to digital. It's certainly part of our argument that that's how it should proceed in this manner. If this case is allowed to proceed, notwithstanding the other arguments I'm making, which I think are very important, that this sign was taken down, use extinguished, et cetera, notwithstanding that, to allow a real property owner to file such a appeal without the consent of the property, the use property is what I'd call it, I guess. Again, billboards and cell towers probably being the only two examples. It would be akin to allowing a building owner to apply to this board to usurp Verizon or AT&T's rights to their cell tower equipment on top of the building. I just don't think it follows. I understand the chairman's point. If this was an industrial use or an industrially zoned building that had an office use in it, and that office tenant left and the owner of the land wanted to use it for another use that's permitted by conditional use in industrial zone, certainly he could come forward without the consent of the previous office tenant, because that's different. The use doesn't run with the structure itself, but there's only one use for an outdoor advertising structure, and that's a billboard. So to usurp Clear Channel's rights by applying without their consent on this property, I think is a key issue here.
But isn't it the right of the property owner to still control that use of their land?
It's the right of the property owner. If I agree with the chairman's point that if Clear Channel wanted to change one of its sign to digital and the owner of the property did not want them to do that, which is sort of the reverse of this situation, I think the chairman has a point. But when the use is the structure itself, and the board has a history of accepting these applications from the billboard companies to control that property, then to allow a landowner to seize control, if you will, of that use, I think would be improper.
But in this case, the initial appeal concerning this billboard, wasn't it filed with the consent and approval of the landowner?
It was filed by the landowner. That's the point. It was filed by the landowner to change my client's property.
No. I mean, back when the initial use was, I think it was, what was it, 99 or something like that? That appeal, wasn't that an appeal that was filed with the approval of the landowner.
It was, and again, that's what I just previously stated. If Clear Channel wanted to go, it would need the consent of the landowner. That half of what you're stating, I agree with. The half I don't state is the reverse doesn't hold true. That the real property owner could come in when Clear Channel owns a sign on the property, and without Clear Channel's knowledge or consent, seek to seize control of that
as
sign.
I understand it, and I understand that there's a dispute as to whether or not there was a right to terminate the lease and all that, and I think that we've already handled in the prior discussion that that's an issue that's not before us, and we can't address that. We can only take the facts as they are, which is that there was a termination of the lease, and Clear Channel only operated the billboard on the property pursuant to a lease. They secured the initial approval to operate a billboard at the premises with the consent and authorization of the landowner. So then, if there's a termination of that lease, are you then saying that the landowner is no longer able at that point to make use of his property as a billboard?
Not when that lease included provisions that survive the termination of the lease to allow Clear Channel to remove the sign, not when that lease arguably, and I'm going to put things on the record regarding this, I know we're not going to get into litigating the lease, but there are things that need to go on the record here, and I'm going to urge that I be allowed to put everything onto the record regarding my motion. The lease, we would argue, changed to a month-to-month lease, but most importantly, not if that means that the landlord is then allowed, without a demo permit, I might add, the city may want to speak to this, go and take down Clear Channel's property without their consent. Clear Channel had a right under the lease to remove its property as it saw fit, and the reason for that.
Well, that's the breach of lease issue between the two.
But that speaks to the issue of abandonment that we, again, we're getting a little bit ahead of ourselves, but if you're going to get into the issue of abandonment, Clear Channel certainly had a right to, and they did, file for a demo permit to take down their sign and extinguish the non-conforming use. And they sought to do that and were prevented by the appellant from doing so. And we'll get into that, unfortunately. Again, I think that this is a very unique situation regarding use, and specifically non-conforming uses. There's a moratorium that the city enacted, which I think makes this unique. A lot of unique issues that I don't think just simple language in the outdated zoning code is going to necessarily
may or may not be, but it's what
the
we've
issue.
got.
Well, that's certainly true, Mr. Chairman.
Okay, proceed.
Thank you. Again, I would call Mr. King. I don't know if has he been sworn?
No, you weren't. Okay.
You solemnly swear or affirm under the penalties of perjury that the testimony you give will be the truth, whole truth, and nothing but the truth.
For the record, Mr. Chairman, I object on the grounds that CCO should not even be here, that has no standing to be here. Just want to make that clear for the record.
I understand. Proceed, Mr. Wolf.
Mr. King, introduce yourself to the board, please.
My name is Joseph King. I'm the Senior Vice President for Real Estate and Public Affairs for the Northern Region, which encompasses this market.
And how long have you been employed by Clear Channel?
I've been employed by Clear Channel since August 2004.
And describe your knowledge of the billboard industry in Baltimore.
In August of 2004, I was hired as a real estate rep in the Baltimore, Washington, D.C. branch. In 2005, I was promoted to a real estate manager position in the Baltimore, Washington, D.C. branch, where I would oversee the lease portfolio and assets.
And have you been involved in applications to this board for the conversion of static billboards to digital?
Yes, of the 19 conversions, the digital conversions Clear Channel has, I've done all of them.
And have you ever been qualified and testified as an expert in billboards in a court of law before?
Yes, I've been qualified in Prince William County as an expert in billboards.
I would introduce Mr. King's resume. We'll call this Exhibit A. If Mr. Sherr would like to take a look, he hasn't had a chance to see it.
Mr. King, one question. You said that you've been qualified as an expert in, I think, Charles County in billboards?
Prince William County,
Prince
Virginia.
William County. Of course, the zoning laws for each jurisdiction are different. Can you just get into the circumstances under which you were qualified as an expert in Prince William, Virginia?
The circumstances in Prince William was qualified was in the context of a condemnation. And there it was about the billboard zoning, the land use, the permits, the lease, sales techniques, really all facets of the billboards. From that, if you want to take direct knowledge here in the Baltimore market, dealt extensively with zoning, with the digital conversions here, as well as land use within the zoning code for the billboard portfolio.
Okay, thank you.
May I have one, dear witness, for just a second?
Please,
But
Mr. Chair.
you've never qualified as an expert in Baltimore City Circuit Courts, have you?
No, I have not.
And as an expert witness with respect to billboards?
I have not qualified as an expert witness in Baltimore. I have been a witness for Clear Channel in Baltimore City.
But have
in
you
circuit
qualified
court.
as an expert?
No, sir.
Have you qualified as an expert before the BMZA?
No,
with
I have
respect to
not.
billboards? I object to this witness testifying as an expert.
To hear your concern, Mr. Sherrill, let Mr. Woolman proceed.
Well, I'll submit the exhibit, Exhibit A. Mr. King, you're an attorney, is that correct?
Yes, as graduated from the University of Baltimore 2003.
And expand upon, if you will, your answer to the chairman regarding your knowledge and your familiarity with the BMZA and the process of applying to the board for Clear Channel.
For the process for the digital permits, we went really from, I'd say, A to Z with that, working with developing outlines, the land use, the zoning, putting forth the exhibits, putting forth the packages and outlines as far as submissions on all sides of it. And then from the BMZA decision, handling the permitting through initial permitting to final permitting, and developed in all aspects of the build-out.
Mr. Woolman, what's the purpose for which you're offering, Mr. King?
Well, Mr. King, if accepted as an expert, and again, I certainly recognize that the rules of evidence don't apply to administrative proceeding, but again.
Do but don't.
Do but don't. Do but don't's a good way to put it. I think it certainly is something we would like to have acknowledged on the record. I'm going to be asking Mr. King a series of questions related to fairly technical issues regarding the billboard industry, regarding the permitting of billboards, regarding the process before the BMZA, which he's been involved in 19 such cases, and for that reason, I'm offering him.
Well, Your Honor, Mr. Chairman, I object. The issue before this board is not this gentleman's expertise in studying billboards and processing billboards and applying for billboard permits before the BMZA in Baltimore City. The issue is who owns a non-conforming use. And does this evidence have anything to do with who owns this non-conforming use? I respectfully submit it doesn't. That is a legal question for this board to decide, and not based upon whatever facts that this gentleman puts forth as with respect to how they've applied for billboard permits in the past.
I'm inclined to say that you're right, Mr. Chair. Mr. Woolman, I think that we'll allow you to proceed with your witness and put on your case with the caveat that I think that the issues involved with the there are some, I guess, competing threshold motions here between the two. As I said at the beginning, I think that Clear Channel's position is that Utah doesn't have the right to proceed because it's not the quote-unquote property owner, and that only the property owner can control what happens with the conditional use, and that as they're not the owners of the conditional use, they can't do anything with it. Their position, I think, is stated in the opposite, which is that you have no standing, or your client, rather, has no standing to be here because they were only on the property pursuant to a now terminated lease, and and so since that lease is no longer in effect, your client no longer has any interest in these proceedings. And so they question your ability to participate. Mr. Scher, is that accurately sort of capturing it?
That is accurate.
So those are threshold questions. The answer to either one, I think, knocks the other of you out. I'm not sure that that's a question that needs a lot of testimony. I'll certainly want to allow you to put on your case and structure your argument. But I do see this as being more of a legal issue than a factual one. And we all know we can't proffer expert witnesses to tell the tribunal what the law is. I mean, I think we can sort of figure that part out. But I think that because of his extensive history with prior matters, that he may have some factual information that may be useful. So, by all means proceed in that fashion, but I do want to keep this from getting too far afield.
I understand, Mr. Chairman. I would just, to comment on your statement, also indicate that there is the additional issue that I continue to raise, and that is that there is a revocation, and that's, I understand that's a secondary issue.
Well, the
but I think it's an
revocation,
important
I
issue.
think, comes in the way that I see this, that there are, these are consolidated appeals. So we'll hear the issues related to the appeal in 2014-64 first, as that case arrived here first, and then we'll hear the issues involved in the revocation after we've heard.
Thank you, Mr. Chairman. Mr. King, I show you what I've marked as Exhibit Number 1, and the Chairman actually already referred to this. This is the August 12th, 1999, you were correct, 1999 decision of the BMZ. Do you recognize that document?
Yes, I do.
And what is that?
It's the original BMZA decision to allow for the removal of an existing rooftop general advertising sign and construct a double-faced freestanding general advertising sign in the parking lot at Clipper Mill.
And Clear Channel had a predecessor and interest in this matter, and that was P&E Media, is that correct?
Yes, we did.
And that's the billboard company that's represented in that decision, correct?
Yes.
Can you describe to the board what was required by the board in that 1999 approval?
Was required by the board, they approved that a billboard could be built in the parking lot and the rooftop sign could be removed. And the proposed height was to be limited to 75 feet. The size of the billboard was to be 2 14 by 48 foot faces. And it went on to say that no tri-vision is allowed on the subject property without meeting the community organization obtaining subsequent BMZA approval at a public hearing. And just for what tri-visions were I would say, the grandfather to what the digital signs are today. They were a mechanical, changeable message sign, whereas the digital is the electronic message sign.
So what was required by the landowner at that time to do in order to allow the billboard company to construct the billboard?
At this time, as part of the BMZ decision, we would have looked to remove the rooftop sign, and we would have had the landowner would have given us, they would have had to okay as far as the billboard company applying for the use.
And what did the board require for any future changes to the sign that was approved back in 1999?
Any future changes they would need to, and I'm going with the tri-vision being analogous to a digital sign, there would have to be meetings with the community organizations as well as the subsequent BMZ hearing for the change.
So to change that sign, you needed to get BMZA approval.
Objection, that's not what the witness testified to, nor is that what the document says.
Noted. You can proceed.
I show you Exhibit 1.1. Can you
Overruled for the record.
describe what that is, please?
The Exhibit 1.1 is recent screen grabs showing that the rooftop sign still exists at 3600 Clipper Mill Road. The panels have been removed, but the uprights and the structure are still atop the building.
I'll offer Exhibit 1 into evidence, which was the prior decision, which may be in the board's file already.
I think it is, but we'll take it.
No objection.
Again, that would be Exhibit 1.1 as well. Thank you. I'll now show you Exhibit 2. Do you recognize that document?
Exhibit 2 is the lease between Clear Channel Outdoor and Utah Property Enterprises.
And recognizing that this board is not here to litigate the lease, I do want to call your attention to some language in it, though, particularly paragraph 2.
But, Your Honor, I hate to keep objecting. I hate to treat this as though it's a court, but, and the rules of evidence do apply, but the lease is, you've already stated, for the record, that the lease is a matter of law, not to be decided here today. Lease issues are not to be decided. So introducing the lease is going completely contrary to what Your Honor has just ruled.
And I would argue there's certainly factual questions that you, Mr. Chairman, have alluded to need to be testified to. There are factual issues that this lease relates to. We're not asking this board to rule on the validity of the lease, to enforce the lease. This isn't a declaratory judgment action, but there's certainly items in the lease that we will bring out later during Mr. King's testimony that certainly apply to the factual scenario and the history of this matter.
The objection's overruled. Mr. Scher, your position is noted. And Mr. Woolman, well, to both of you, yes, we have stated that, and I think that everyone understands that legal issues or legal disputes related to the lease, we don't have the authority to resolve, but we certainly can take notice of the lease and contents and the facts surrounding it, but we're not equipped to, with the jurisdiction to determine any disputes resolving.
Thank you, Mr. Chairman. Again, paragraph 2, Mr. King.
All signs, structures, equipment, and materials placed upon the premises by the lessee shall always remain the property of the lessee and may be removed by the lessee at any time prior to or within a reasonable time after the expiration of the term hereof or any extension hereof.
And was there anything in the lease that allowed Clear Channel the right to remove its sign after the lease terminated?
Mr. Scher, an objection?
Yes, your objection. I'm trying to take notes, stand here and object. Thank you.
That I'll sustain an objection to.
I'll offer the lease as an exhibit into evidence, and the lease speaks for itself regarding that plain language.
The proper way to hear.
Very well.
Would you share any objections other than what you previously stated?
I would just renew my objection based upon what I previously stated for the record. But
it's overruled, and we'll receive it in as Exhibit 2.
Exhibit 4, Mr. Chair, is just a document. I don't think there's any dispute to this, and if there is, we'll elicit testimony. But this is just a corporate chain of custody regarding P&E being the predecessor in
Can we just back up for a
interest.
second? I have Exhibit 2 being the lease. What was this Exhibit 3?
There is no Exhibit 3.
Yeah,
There is no Exhibit 3. Okay.
And just for the board's education, I've marked the exhibits consistent with how they were marked in the memorandum that was presented before you opened. That would help to some degree. And again, this is simply a bill of sale indicating that P&E was the predecessor in interest to Clear Channel. If there's no objection, I just want to put that into the record. I don't think anybody's disputing that.
Share any objection?
No, Your Honor.
And for efficiency's sake, Mr. Woolman, did you want to, were there specific exhibits in your motion that you wanted to move into evidence?
I'm going to go through each of them.
Okay,
Sure.
so
Much
all
to the
of
board's
them
chagrin, probably, but I'm going to go through each of them.
All right, so it's your intention to admit all of them?
Correct.
Okay. And Mr. Scher, did you want to take a moment to go through the exhibits, identify which ones you have objections to, and we can see if we can
Yes, I
do this
would
in
like
a streamlined fashion. Okay. As I see it, we were on the bill of sale, right?
Correct.
And there appears to be, I guess the next is the certificate of ownership and merger. I don't know if these are all part of the
Yeah, they're all
same
part of
document.
the same document, exhibit
Okay.
4.
And including the schedule of assets, which presumably, yes, it does, contains the billboard at this property.
Correct.
Okay, so, Mr. Scher, any objection to this?
I'm sorry.
Sure, we're just going through what is the bill of sale, and which is the current exhibit. So there's the bill of sale, there are, and then it looks like there are some addenda. So there's the certificate of ownership and merger. There are certificates from the Delaware Secretary of State. I believe that those are statements of good standing, or I guess, no, just of the merger. Then there's certificate of amendment and the schedule of assets.
To the extent that I believe it's totally irrelevant, but I would object to that.
Okay. That objection is noted, and we'll admit that. Then it looks like there are all of the rent checks or a number of the rent checks?
Yes, and that would be a part of Exhibit 5, which I can have Mr. King testify to as well. There's rent checks and a lease percentage report.
I'm not sure, again, what relevance the rent checks have. The lease is expired. I don't think anybody disputes the lease expired as of October 31st, and no one is in effect. I'm not sure what relevance the rent checks were while the lease was in existence were made. It just complicates the record.
Okay.
Obviously,
So-
we disagree that there's no dispute there, and I'll ask Mr. King some questions about these
So,
checks.
subject to, I'll presume, Mr. Woolman demonstrating the relevancy of the rent checks, we'll look at those.
I do object to this letter.
Okay.
This is a letter written by my client, in which, in the memorandum, Mr. Wallner takes on my client, accuses him of being misleading the board and the city, and totally, again, totally irrelevant, totally spurious as far as I'm concerned. It should not be. It's simply a basis for argument. It has nothing whatsoever to do with this case. It's 1201 South Sharp Street. It has nothing whatsoever to do with this case.
Mr. Woolman?
I'll defer to the board regarding that one particular piece. I believe the memorandum was actually submitted back when there were 2 cases that were filed to the board.
All right, we'll pull this out. Easier said than done. All right.
I do very much object to any circuit court or court of special appeals unreported cases being included by the record. We all know, or at least all the lawyers standing here, all know that it's improper to cite trial court cases as precedent, and improper to cite court of special appeals cases that are not reported. And that's what Mr. Allen is relying upon, and for those reasons I strenuously object to these cases.
Well, Mr. Chairman, as we've obviously already stated, the rules of evidence and the precedence rules don't apply at this juncture. And I find it interesting that Mr. Scher is opposed to our citing a Court of Special Appeals opinion, albeit unreported, when he is citing previous board decisions of the BMZA and trying to offer those as precedential value. So I believe they should all come in, Your Honor.
Completely distinguished.
Well, I think that by the rules of the Court of Special Appeals, their unreported decisions aren't to be relied on for precedential purposes.
Not to be relied on for precedential purposes by the Court of Special Appeals, the Court of Appeals, or perhaps even the Circuit Court. I think, given the unique situation here and the fact that
But the only reason why you're
administrative
citing them is to convince us of the rationale or the reasoning provided by the Court of Special Appeals. So I think that that should probably be excluded. And I hear your argument as far as citation of prior BMZA opinions, and we'll deal with that when that issue comes up.
Very well. Again, for the record, but this is just for the record, I would state that given the fact that, in my opinion, a lot of the issues here regarding this use, the specific unique use of billboards is at issue, that certainly the board could make available to itself opinions, although that they be unreported, of a judge, even in circuit court for that matter. I would just offer that that's the reason we tried to get it in. I understand the objection and your Honor's sustaining of that objection.
Okay. Next, we have decisions and appeals of the BMZA and the sorted other matters. I'm not sure if there's a particular number, but...
I believe it was Exhibit 10, if I'm not mistaken.
So 10?
I believe. I could be wrong. If you're talking about the previous cases, that's...
Yeah, so the first one here involves premises designated as 1100 Interstate Avenue, and it's dated to be August 11th, 2008. But there are a number of opinions that are, well, board opinions and approvals for other locations. I'm going to imagine that you're citing it for the purposes of how the board has acted in other cases.
We're certainly not going to...
I don't object to those.
Okay, so we'll put those in as a group. Then it brings us to the permit application, dated This is July 14th, 2014.
Correct.
To, put on the sign.
This is for, to replace existing billboard, same size and same location as the description is provided.
Is this the one that we filed, or is this something that you?
This was the online application that you filed after the BMZA case to get digital was postponed, and then you went and tried to get one online.
Just for the record, sir, if you can identify yourself. I understood that, but we just needed to say. And I think that Mr. Hemworth is correct, that this appears to be for a static billboard. It refers to the existing billboard, which I think it was the one that was in place at the time. Okay. And there's the permit that's issued with that. These are all the same, these are all related to that permit application, correct, Mr. Woolman?
Correct.
Okay. And then last, we have the October 22nd, 2014 letter to Utah Property Enterprise from Ganesham K. Patel.
Right, I have no objection. In fact, it says that the permit issued for us to propose the sign will be sufficient. So,
Okay. All right. So, with the exception of the March 17th, 1999 letter and the unreported Court of Special Appeals opinion in Up to Date Laundry, Inc. et al. V. Mayor and City Council, all of the exhibits.
I believe there was also a transcript of Judge Berger's decision, which would also fall in the same category.
You have that attached here. Were you intending on offering that transcript?
Not after you ruled the way you ruled. So no.
Okay.
Not proper, then I don't need to object.
All right. Okay, so, except for the letter, the transcript, and the unreported decision, everything else will be omitted.
And Mr. Chairman, I don't know if you'd prefer to go through them now. There was a second memorandum with additional exhibits that were also submitted to the board that we're also going to be offering. If you'd like to give Mr. Scher the opportunity to review those as well, I certainly understand. And
Well, not to further complicate matters, but what I was going to suggest is that we omit all the memoranda, the three memoranda that Utah Property filed with all the exhibits attached as well.
I think that might be the easiest way to proceed.
That's fine. I just didn't know if you wanted to give Mr. Scher the opportunity to, I mean, we're going to, again, much to your chagrin, we're going to go through these exhibits. I will try to be as quick as I can be, but it's an important record to be created in this matter, as I'm sure you can all appreciate.
Yes. And Mr. Scher, did you have those handy?
I'm sorry, Joe, what are you going through now? Just trying to get some paper.
The second memorandum, which would have been our amended, in support of amended, yeah, there you go. There were exhibits attached to that as well.
David, can you hold that there? This is Utah's response. There was a amended motion, I think. This is the initial one, rather than 216. I think this is the initial one. There was another one that was filed. Did you get there? And Mr. Woolman, you're referring to the, your filing on January 26th?
That's correct.
Okay, and the exhibits are attached to that?
That's correct, Mr. Chairman. And we'll offer those again today, numbered the same sequential manner as they were. Refer to those exhibits as 1B, 2B, 3B, et cetera.
Mr. Chair, over there. Were there any particular
There are some particular,
ones you want to object to here?
yeah, on the second memo, permit for taking down the sign that was filed by CCO was in fact revoked yesterday. So, you know, to the extent it's revoked.
Mr. Woolman, are you going to be appealing that?
Absolutely not, but it certainly isn't dispositive of whether that's an exhibit in this case.
The letter allegedly addressed to me, which I never received, I do object to.
And which one is that?
That is a letter dated December 10, 2014, from Salvador M. Lash. My electronic, must have had the wrong, must have sent it to the wrong place, because I never received that.
I'm sorry, can you close this to the mic, please?
We had at some point, Clear Channel has general counsel, and they, or Clear Channel, actually, Steve Ginsburg was here, asked if they minded if we sent something to our lawyer, and it was about a contractor trying to resolve it. My suggestion was that we engage Jeff to help us with, Jeff shared specific things, but as it related to the contract and other stuff, we suggested he call us directly. So
Okay.
he was actually sent this, or it's included in there. I've never seen it, or I saw it only when it came across in this memo, and Jeff also claims he's never seen it, or claimed he had never seen it.
I have never seen it.
Okay, all right. So I think that if Mr. Scherer didn't receive this letter, Ms. Woolman, I think that's probably excluded.
Well, I think it speaks to the weight that the board can or cannot give to it. The reason we're offering it is to frankly show Clear Channel's mindset at that point, not necessarily whether or not, I mean, we sent it, we don't understand why it wasn't received. So I'd still offer it into evidence for that purpose.
I think you're right there. We can, Clear Channel as author of the letter can certainly account for the fact that that it is an authentic letter that they wrote. Whether it was received as addressed or not is another matter altogether. But as far as if it states what their position is, I think that that's fine. Aside from the fact that it may not have been, well, it wasn't received. I'll take your representation of that.
Sure.
Fact. Okay, were there any others?
I think those are all the exhibits that are attached.
Okay.
Should we stop now and move in all of the memorandum refiled?
We can let Mr. Woolman advance with his, actually, you know what? No. Yeah, let's put in everything here. all done at once.
Here are the three. Here are the three memoranda that we filed for
Okay.
exhibits attached. I would move to admit all of those.
Okay, and Mr. Woolman, you had no objection to the various
One
exhibits
moment.
attached?
No, Your Honor.
Okay.
Mr. Chairman, Your Honor.
Either one is fine. All right.
Your Honor's referred then.
Is he like that?
All right.
Do you want to give him a robe? Do you want to give him a robe?
I think technically it's Mr. Chairman. But, all right. A couple of things before we go forward. We're going to take a quick break for a few minutes. And then when we come back on the record, the way that we'll move forward is this way. I have some concerns about this becoming a little bit unwieldy. And I think that I know in my practice I always do better with some time limitations. So we're going to apportion 20 minutes aside. So from when we come back, I'll note the time right now is being 2:41, so we'll come back at 2:46. So Mr. Woolman, you'll have until 3:06, and then Mr. Sherry, you'll have, and I'll give you a little bit of leeway because I understand he's presented a little bit to this point, but you'll have from, I guess, until 3:26. Okay, all right, we're going to take a 5-minute recess.
Thank you.
Okay, and are you here on, I guess are you here on the substantive matter of the appeal?
I'm here on the aesthetics end of it, I guess, because my neighbors, we come home to it every day.
All right, so right now, we're dealing with some preliminary issues involved in the appeal. So you can have a seat until we finish with that part, and to the extent that there's anything that remains, we can address your concern.
Okay, thanks.
All right, and Mr. Woolman, and I'll note the time is 2:50, so with the parameters already being established, you can proceed.
Thank you, Mr. Chairman, and with the understanding that we've already reviewed objections and rulings from the board, I will try to get through these as quickly as I possibly can. We left off on exhibit number 5, which were checks. There was also, I think, a lease percentage report, but I would just introduce that. Mr. King, was there a check accepted by the appellant from November of 2014?
Yes, there's a check accepted by November 1st, 2014.
I'll show you what's marked as Exhibit 6.
Objection, Your Honor. I understand we did not accept the check.
Okay, was that one of the, well, I think that we can deal with whether the check was or wasn't returned when you can clear them. You can clarify that, Mr. Sher.
This is marked as Exhibit number 6, which is a personal property spreadsheet. Could you quickly explain to the board the purposes of introducing this?
This would be the Clear Channel owned structure net asset book value of which we base our personal property taxes on in the state of Maryland, Baltimore City.
Very well. And then identify this document as well, please.
The document here is our outdoor advertising excise fee payment that we make to the city for all sign structures within it. On pages in 15 and 16, we've highlighted the CC-owned structures owned on 3600 Clipper Mill Road property.
Thank you. Sorry, that was number 4. And marked as Exhibit 10 is the prior BMZA cases. Again, I think the chairman has already alluded to why we were introducing this. There's nothing really more to elaborate other than to have these in the record, and there's actually a giant binder of them, and they're labeled that we would put into the record.
All right. I'm gonna guess the one was
Exhibit 11, could you identify this quickly, please?
Exhibit, excuse me, Exhibit 11 is a copy of the online application made by Utah Property Enterprises to replace the existing billboard, same size, same location.
And how did you become aware of this online application?
We became aware in an internet search that popped up on the city's BMZA page, the Baltimore City search page.
And was this a surprise to Clear Channel?
The online application was a surprise to Clear Channel for a number of reasons. One, at the time of this, we had an existing structure that CC owned on the property. We also, to the best of my knowledge, were in active lease negotiations for lease extensions with Mr. Himmelrich and Utah Property Enterprises. And then lastly, as I have pulled many of the applications in the city over the last 10 years and all the digital applications, seeing that a sign application was allowed to be submitted online was out of the norm, in that I've been told that I'm not allowed to.
No objection. Witness not qualified as an expert on applications.
He's not testifying as an expert. He's
I
testifying
understood
as
it that he was testifying from his experience in other matters.
From my own personal experience and knowledge, I've been told that I cannot walk through sign applications, and I need to go through the one-stop permit shop and go through the normal procedure. The other, in looking at this, we've always been held to a standard of listing the prime contractor with a license number. That's not done on this application as well. An electrical contractor with a license number to electrical work has been done. That wasn't done on this application.
And was there a BMZA application for the same thing pending after it was postponed in April?
There was a BMZ application, to the best of my knowledge, postponed for the digital conversion at this site.
Thank you. And speaking of that application, I'll show you Exhibit 1B, which is that application, is that correct?
Yes, 1B is the application to the BMZA, similar to the one that we would submit for a digital conversion. The one note here that seems to be different than all the ones that I've done or seen is in the existing and the proposed section of use. It does not list a billboard or general advertising sign as either an existing use or a proposed use in this application.
And does this application indicate a request to change an existing sign?
It is rebuild and reface both sides of an existing double-faced general advertising sign.
And this was the application February 20th, 2014, correct?
Yes.
And who owned the sign on February 20th, 2014?
At that time, the sign was owned by Clear Channel Outdoor.
And what is different about this application and all the applications that are included in the binder we just submitted?
In all the applications included in the binder, the owner of the billboard, Clear Channel, has been the one that applied for the digital conversion of their structure, which is the use and the asset.
And upon learning of this application, you retained counsel, is that correct?
Yes.
And you attended the first date before this board, is that correct?
Clear Channel Outdoor was at the first date, yes.
Mr. King, I'm not going to make you go through each one of those applications that's in the binder, but is your understanding that the typical procedure when I guess when an application is made for the erection of a billboard, that that it's necessary to have the property owner's consent for that?
Yes, we have normally in all of those instances, but one where Clear Channel was the owner of the underlying real property, we have a lease with the owner of the realty, and being the owner of the billboard, we would seek permission from the owner of the real property, in that we're going to be doing work on their property to our property. A little bit confusing, but that's we've had to get their consent in order to make application.
Okay. And in this case, as I understand it, this situation hasn't come up before where the lease to operate the billboard has expired or terminated or what have you, and there's a property owner who's seeking to proceed with operation of a billboard independent of Clear Channel, has there?
There has not been, and to note, at the time of this application, 2/20/2014, Clear Channel had a structure on the property that we owned and operated, as well as we had a lease in full force and effect. So as a surprise to Clear Channel, we have a lease that's in full force and effect, and we have a property owner against, and it goes to the contract, but against our lease, applying to build a billboard on the property, a new sign structure on the property.
Okay.
And just to follow to the chairman's questions, in every application in that binder, Clear Channel is listed as the appellant and the applicant, correct?
Yes, we represented at the hearing.
Mr. Chairman, this is Exhibit 1B1. I don't think Mr. King needs to testify. This is an affidavit that was included in our memo about a statement made by Mr. Himmerich at the hearing in April regarding ownership of the sign that existed on the property.
This has to do with some of the hearing and some statement that Mr. Himmerich originally made?
This was a statement made at the hearing in this matter before this board in April 2014. Not on the record before this board, but a statement made to the affiant.
I object.
It strikes me as hearsay. Yes, the rules of evidence are flexible, but given that Mr. Himmerich is here, I think that might be a little bit too far.
Very well.
We'll exclude that.
I'll show you Exhibit 2B. This is the online application, which I think we already introduced as Exhibit 11 earlier, and also our negative appeal. You recognize those, correct?
Yes, I do.
And why did you have my office file negative appeal on the online permit?
Well, a negative appeal on the online permit, our feeling is that Clear Channel would be the one that would have the right, the use to build a sign structure or to convert a sign structure to digital, not the property owner, as well as in review of the plans associated with the permit application, we felt that they did not represent the work being done. And
why does Clear Channel have that understanding, that is, that a property owner can't seek a permit on their own, independent of Clear Channel, to operate a billboard on their premises?
In our understanding of the moratorium, the Baltimore City moratorium on new signs, a permit cannot be issued, and reliance on the up-to-date laundry case as it evolved with.
So, as I understand the moratorium, that says that you can erect a new billboard, but that billboards may be replaced so long as they don't exceed the dimensions of the pre-existing billboard. Is that correct?
I would argue no, that that's not the case. And with the moratorium, and Baltimore cited the nuisance of billboards, as well as with the outdoor advertising excise fee, and their deleterious effect on the community and the city. So as to move forward with, say, you could just rebuild and replace any billboard, it goes against the, I'd say it goes against the sign code and it goes against the spirit of the moratorium.
So it's your understanding that the moratorium doesn't allow the replacement of a billboard on the same place and site of a pre-existing billboard?
My understanding is that as it would play from up-to-date laundry, the billboard structure itself is the use, and being that the moratorium is how it differentiates itself, I'd say distinguishes itself from cell towers and other uses, we'd say like an office building or restaurant. With that moratorium in place, it really, the structure is the use, and once the structure is gone, the use is gone.
Okay. Well, what if the structure was still there, and an applicant wanted to take down and replace what's there? Would they be able, is it your understanding, well, what is your understanding as to whether or not an applicant would be able to do that?
Just the sheer presence of a structure itself would not give the right for a property owner or a third party to replace that existing structure. They would have to own that existing structure in order to have the right to replace.
Okay.
Does that count against my 20 minutes?
I'll give you 2 minutes.
Okay, exhibit 3.
Yes, this is a letter addressed to Clear Channel from Utah Properties Enterprises, dealing with the removal method imposing restraints or constraints outside of the lease.
And why do you think Mr. Himowitz sent this letter?
Multiple reasons. One would be to frustrate the removal. Two is that way the structure would not be removed while the BMZ and permit applications were working through. And I guess lastly, third, one of the reasons was to use the existing footer.
Exhibit 4, that's a letter from Clear Channel, correct?
Yes, Exhibit 4 is a letter from Clear Channel to Utah Properties, Inc., dealing with that we can't be denied access, and it's us to remove the sign structure in a reasonable time.
Exhibit 5 is the demo permit that was apparently revoked yesterday, which I find very interesting, the fact that council was aware of that. We were not aware of that. Can you describe that demo permit? I'm sure that's the case.
This is a demo permit.
You get paid more than me, so I'm sure you are.
This is a demo permit by Clear Channel Outdoor to remove the existing Clear Channel-owned sign structure at 3600 Clipper Mill Road. As part of that, we were extinguished the non-conforming use.
Thank you. Exhibit 6 is what I'll refer to as the clarification letter. Do you recognize that?
I recognize this. I've never seen one of these. This was the first instance where I saw a clarification letter. And the blueprints that were submitted as part of the online package reference the scope of the project was to build a back-to-back digital sign. And this was a clarification letter saying that the permit that was issued and then later revoked was not approval to build it digital.
And that brings me to the plan. I think you've got a larger copy that we can introduce to the record because it's easy to read. When Clear Channel became aware of this online application, we took a meeting with the zoning administrator. Is that correct?
Yes, we did.
And part of the purpose for that meeting was to actually see the plans that were submitted as part of this online application. Is that correct?
Yes. We went to see the plans. The plans originally as submitted online did not have a seal as required, but in office there was sealed copies.
And I'll mark this as Exhibit 2B1 to go along with the online application. And when we reviewed this in Mr. Reveal's office and eventually obtained our own copy, was there anything that was alarming that we noted regarding the plans?
As the plans are replacement in kind, we were alarmed that the overall height here is showing a 65-foot sign, where Clear Channel sign was 75-foot overall height, as well as we have a spread footing foundation at the location. These plans are showing a drilled shaft, column pole foundation, as well as in the notes section, it applied that the unit has been designed to accommodate 2 LEDs, as well as in the scope of the project, it said a 14 by 48 center mount billboard at 65-foot overall height with 2 9,702-pound LED units located at 36 Clipper Mill Road. It's a little bit setback that 1, there was an online sign application made, 2, that there was an online sign application, the blueprints that were submitted gave a project for digital.
And was the BMZA request to do digital still pending at that point?
Yes, it was.
I'll introduce this as Exhibit 2B.1. Did Clear Channel raise its concerns to the city at that point?
Yes, we spoke with the building inspector's office and raised our concerns that at that time what was built on the property at 3600 Clipper Mill Road did not match the sign blueprints as set, as put forth.
And was the clarification letter, quote unquote, was that sent after you raised your concerns to the city?
Yes, the clarification letter said about it wasn't approval for digital, even though the scope of the project specifically details digital.
And have you ever seen a clarification letter on a billboard permit before?
I have not. No first.
Has CCO?
Objection. It is what it is. There's a clarification. Well, you said it before or not, it's totally right.
Has Clear Channel ever asked or received a clarification permit on any of its billboard permits?
No, to the best of my knowledge, we have not.
I'll show you what's marked as Exhibit 7B. This is a letter from Mr. Himowitz. Do you recognize that letter?
Yes, I recognize this letter.
And what was the purpose of that letter?
The purpose of this letter was, okay, Utah Properties, a Clear Channel, again asking for the sign removal methods asking for drawings of the foundation or that we leave the foundation in place for use. And it also went forward to say that they are not necessarily requiring Clear Channel remove the sign structure, but if we are, that we need a specific schedule. Again, this goes to that why there was an active appeal and the permit issue going on, that the billboard did not need, was not to be removed from the property to maintain the use and the structure in existence.
And did you send rent checks to Mr. Himmerich after this?
Yes, we have.
Objection, after what?
After that letter, the date of that letter?
It's October 28th letter. There was a rent check mailed 11/1.
But
Order.
Mr. Himmerich has already testified, I believe.
I'm not sure that he's testified yet, but I understand. I'm gonna imagine that you have a response to this issue of the checks being mailed, and I think I can understand what your response is gonna be, but I'll let you present it.
We've got like 3 minutes, so really quickly, introduce Exhibit 8B1, which is the violation notice issued by the city. There was a stop work order issued at that time as well, is that correct?
Yes.
Exhibit 9B is another letter from Mr. Himmerich. Are you familiar with this?
Yes, familiar with this letter. This is a letter that says, over the weekend, letters dated December 8th, that Mr. Himmerich elected self-help or his contractors to remove the CCO sign structure from the property. Over that weekend, we learned by personnel driving by that a new sign had been erected, and if Clear Channel wants its property, it has to pay Mr. Himmerich $8,750 to collect its billboard from his property.
Did Clear Channel authorize the removal of its sign at that point?
Clear Channel did not authorize anyone to remove its sign structure at that point.
And these are photographs, I'm assuming these are photographs of the sign after it had been torn down and was lying in the parking lot. That's Clear Channel's sign, correct?
Yeah, Exhibit 91, pictures a Clear Channel sign, and it goes on.
Again, I have to object. I'm not sure what the relevance of all this is. The fact of the matter, the sign was taken down. Whether they have the right to take it down, they have the right to take it down, it's a legal dispute. It has nothing to do whatsoever with this board's going to rule or not.
Understood. It's denied. And we'll
Is it
accept.
10B?
10B was a letter from Clear Channel Council to Mr. Shear. I understand that there's open if this was received or not. This goes to Clear Channel's intent that we did not approve the removal of the sign structure. We asked to cease and desist from the unauthorized use of our structure with the foundation and the bolts that were used.
And this is the revocation letter from the city, you recognize that, correct?
I thought that was stricken from the record.
Yes.
Which? No, it wasn't stricken. We said that they can certainly testify to the fact that the letter was authored and that it was sent, that it, I understand from your representation, it was not in fact received, but they can still say that they drafted it, they sent it.
And this is the January 16th letter from the city to the zoning board regarding the revocation, correct?
Yes.
And did the sentence, I'm sorry, this is the wrong one. B. 12B is another letter from the city. That's a letter to the board as well, correct?
Yeah, a letter from the board as well, stating the city's position. Revocation of the permit impacts the existence of the non-conforming use upon which the conversion is based, digital conversion is based.
And did that letter provide some relief at that point in your mind?
Provided some relief that there was not a legal structure there to convert.
Exhibit 13. This was an additional letter, correct? From the city to the board?
Yeah, additional letter to the city to the board, just going through the chronology of the permit issuance and the revocation.
And did that letter raise any concerns regarding your comfort level regarding the non-conforming use?
Objection. Comfort level? Ms. Burns' letter, raising comfort level?
You may answer.
Yeah, I mean, a good comfort level that, again, it wasn't a legal structure in order to base the digital conversion.
And then Exhibit 14. That's a letter from Mr. Barry, correct, regarding the as-built plans?
Yeah, Exhibit 14 has the as-built plans. This letter, to me, brought some concern. At one point, it says that the approved height of the new sign was 75 feet, but the 65 feet basically was an intent to replicate the 1990 sign, but it was an error, is that it was, the owner, Mr. Himmelrich, I assume, or Utah Properties, was not unable to get the blueprints from the city to show that the height was 75 feet. The engineering firm that was used, Bennett Place, was the same engineering company that built the sign structure, and they seem to have record. That's who certified the as-built engineering for Utah Properties.
And then finally, you were able to pull a copy of the as-built plan, correct? This is our last exhibit.
Yeah, if we pull the as-built plans brought to some concern. One would be that that the existing CCO foundation was used. Two things for the 2012 IBC, it is required that seismic loads be included onto the blueprints. They were not, as well as the 2012 IBC. It's required that ice loads be required on the blueprints. They are not here as well. There's a note that says the foundation designed based on soil boring B3, and it lists DW Pizzera Inc. dated 7/7/14. The foundation was designed based on a soil boring in 7/7/2014. However, there's multiple notes on here that says the foundation and the re-engineering is existing. So it's a question of how do we engineer a foundation based on a soil boring that was already pre-existing. Again, the other issue is its 65-foot overall height, and these plans again submitted as the as-built reference designed to support 1,000-pound LED faces on each side, and there's a discrepancy in the uprights between the plane view and the sign frame view.
And with reference to the existing footing, what's your testimony regarding the ownership of the existing footing?
The existing footing would be that of clear channels, and one thing that struck from the
That would be objection again, Your Honor. That would be an issue for the court to decide whether ownership exists or doesn't exist.
and one in looking at, sir,
That I'll sustain.
and one in looking at.
You sustained the objection. Let me rephrase the question. What's depicted in this plan?
This plan has depicted a spread footing foundation when the initial plan to pull the permit online submitted a drilled column shaft foundation. So it's a complete change in the foundation where the one did not have the drilled shaft, which would have been the clear channel foundation.
And did Clear Channel have, back in February when this case was originally applied for before the board, did Clear Channel have a sign and a footing on the property?
We had the sign.
Objection. Whether or not the footing was a clear channel footing, whether or not they had something on the property, again, that's a legal dispute as to whether or not my client has a right to use it or not use it, whether it's a trade fixture, not a trade fixture, whether it belongs to Clear Channel or it belongs to my client. Not an issue for this board.
How is it a legal question as to what footing is there on the property?
It's ownership.
It's a factual
I think
question.
it's, I'm going to deny the objection, but I think that the point is taken, Mr. Woolman, that the fact that you're trying to establish is just simply the issue of ownership and the overall legal question that's before the board. But
actually, I would just add that this exhibit and combined with Mr. King's testimony indicates that there is a footing on the property that was there in February of 2014 that's being utilized. That's a factual submission that we're making.
Okay, and I'm guessing that you're submitting that issue towards the argument that the property owner is using property of your clients. That still remains.
That's one
the
reason.
property.
There are other reasons well, and not the least of which is to mention the standing argument that's been raised.
Okay. All right. Was there anything further? I gave you a little bit of leeway.
No, thank
you. Okay. Was there did you want to sort of sum up your position in a couple minutes?
Certainly. Again, I'll go back to what I said at the beginning of the hearing. I don't see how this board can hear an application to change an existing billboard. That's what was asked for back in February. That's still the application that's before this board. I found it interesting. Yesterday I went and reviewed the BMZA's files, and as the board is well aware, there's a data draft that is kept for each hearing. And even though the hearing and the appeal number never changes, the description of the proposal changes. I've never seen anything like this before. The first two data drafts say alter an existing general advertising sign. Then, when we move forward to January of this year, it's to rebuild with digital reface existing general advertising sign. Obviously, our argument here is that there is no longer a legally existing general advertising sign to replace or change. I hate to keep beating the dead horse, but I think that issue is fairly clear. There may be future cases involving these parties and other property owners and billboard operators, but when this sign was torn down without a demo permit, without the consent of the owner, the non-conforming use was extinguished. There's case law that speaks to, and I'll cite a couple. Is this my last chance to argue this? I know you want to move forward, so I don't want to belabor any
one question
point,
I would have on that point is, as I understand it, your position is that, well, let me go back. So the application that we have before us in this appeal is to rebuild and reface the existing freestanding double-faced general advertising sign located in the south portion of the lot with electronic changeable digital screens on both faces, same size and same location. That's what the instant appeal is. Now, as I understand it, this was an appeal that was initiated at a point in time when, I guess, prior to the purported termination of the lease and prior to the removal of the structure, that is the billboard. In the meantime, between filing of this appeal and now, there was an online application for a permit that was submitted and was issued. I understand the position as far as the propriety of that, but I don't think that there is a question over that the permit was in fact issued. And then work was done pursuant to that permit at that time. And not coincidentally, there was also a letter from the city that issued to the applicant saying that the permit at that time was believed to be proper, and I understand that that's in the understanding was changed. But that's how I understand the factual percolation to this point, and then there was the removal of the sign and all that. Is it your position that having removed the sign, the existing appeal to remove, reface, all that kind of stuff, that the board can't move forward on that request because the sign has been removed?
That plus a couple of other very important reasons, those being there was an application to this board to convert an existing sign. The sign that existed at the time was Clear Channels. There's no dispute regarding that. The application was to convert that sign to digital. That case was postponed. There were continuing negotiations throughout the summer between the parties. Unbeknownst to the board and unbeknownst to Clear Channel, and I would think the board would take somewhat of an affront to this, an online application for the same thing before here, having been heard before the board and before receiving permission from the board, an end around, if you will, is attempted to pull an online application, and the plans we submitted show, for digital. They tried to get what they asked this board for before the board granted the permission to do so. And that, combined with the removal, speaks very loudly to whether or not this appeal should be allowed to go forward. The existing sign that they applied to change no longer exists. Moreover, the online application and the plans that were submitted with it, once it was discovered by the city, frankly at my client's help, that this was actually a digital sign, a clarification letter is issued, not another permit, a clarification letter. I understand the city and Ms. Burns' office and Mr. Veal's office try to work with applicants and try to do what they can to try to get things done, but that's not a new permit. That's a clarification of the old permit, and the old permit is based on what was there before, and that was Clear Channel sign.
But that same letter, it said that it was legally sufficient at that time. Were they not entitled to rely on that?
Except that you couldn't do digital, so they had to come back in with another plan, and the as-built also shows digital. I mean, Ms. Byrne gave Mr. Hemmerich and his team ample opportunity, I know you're going to hear from her, ample opportunity to try to address these issues, and yet they continue to try to get permission to do something that they need to get from you. And that's the real problem here. This is your classic example of doing something and then asking for permission later. That's exactly what this case is all about. They had a case before you, it got postponed, they went in and tried to do an end around, they were caught by the city flagged, and the city gave them a chance to come in and redo it.
This is hyperbolic argument.
It's argument. I mean, I hope it's somewhat hyperbolic.
I understand that it is argument, and
it's inaccurate.
I can understand the applicant's bristling at some of the components of the argument, but it is argument, and give advocates leeway on that. You can sum up, Mr.
I will cite 2 cases on abandonment in case this is my last chance to address the abandonment. The first case is McClay et al. Versus Maryland Assemblies, Inc. I will refer to the court citing the Landay case, which is Landay v. Zoning Appeals Board, 173 Maryland 460. Perhaps the leading and most frequently cited Maryland case dealing with a nonconforming use is Landay versus Zoning Appeals Board. Landay is authority for the proposition that the effect of a cessation or discontinuance of a nonconforming use must naturally turn on the language of the ordinance. And under the sections that both Mr. Scher and I have cited in the zoning code, if there is abandonment evidenced by the removal of structures, that nonconforming use terminates immediately. So our argument is when this sign was torn down, the use was terminated. And it speaks to, frankly, the long history that we just went through regarding Mr. Himmerich's attempts to prevent my client from taking down its sign per its building permit, which it got. I submit to you that the appellant recognized this issue and recognized that if Clear Channel was allowed on the property to take down the sign, he had a real problem on his hands. And that is that the nonconforming use...
Make the argument, but objection. There's absolutely no evidence in this whatsoever.
I would disagree.
If you can argue, you have to argue based upon the evidence you put in.
I'd be happy to, Mr. Scher. The exhibits introduced, including the letters from Mr. Himmrich, certainly indicate that. You can object, but the evidence shows there are communications in the way of letters from Mr. Himmrich placing extra conditions on my client to go onto the property and remove the sign. He recognized he had a problem to try to get around. The court continued to state that abandonment involves the concurrence of an intent to relinquish an overt act or failure to act which is consistent with that intent, and that cessation or discontinuance without substitution of another use or without evidence of intent to abandon will not prevent the resumption of the nonconforming use. The intent is in the demo permit. The demo permit that Clear Channel got states that we intend to extinguish this nonconforming use. The overt act was the removal.
Really? Well, I'll call you on that one, because as I understand that language, it says that, and it's basically the same language that's embodied within the code, which is that that the question of abandonment looks to the intention to relinquish the use, and so it's. Typically, we see it in the case where, say, you've got a non-conforming commercial use that's made of a corner store, and someone goes in and they remove all of the fixtures, of the counter and the stools and all that kind of stuff, and they turn it into an apartment, and then some point later they want to bring back that commercial use. And you say, well, you can't do that because you terminated that non-conforming use when you changed the dimension of it. By your conduct, you evidence an intent to relinquish that non-commercial use. Can you say that that happened here, that there was an intention to relinquish the non-conforming use that is the billboard, when what was done was one billboard was put up and immediately thereafter another billboard was put up in its place?
It was absolutely...
At the time when there was a permit, whether it was properly issued or not, authorizing that use. Doesn't the fact that the owner went on, whether they went online or whether they did it in person, doesn't that show that there's not an intent to relinquish the use? There's actually an intent to continue the use.
No, I would respectfully disagree, and the reason is this. Clear Channel recognized the situation once the fall of 2014 arrived. They realized that they were not going to be able to work anything out with Mr. Himmelrich. They specifically made sure that their demo permit clearly stated that the intent was to extinguish the non-conforming use. It's clear. The billboard haters in this city, and perhaps maybe some representatives here from the community would be glad to hear that our position is no billboard can be on this property anymore.
Okay. All right. Sure.
Can I have a couple minutes with my client?
Yes.
This is who I just heard. Thank you.
Mr. Chair?
Yes, Mr. Chairman, I'm going to call Sam Himmelrich, a principal of Utah Property, to testify. And because we don't intend to introduce page by page the exhibits as Mr. Woolman did, I'm going to ask Mr. Himmelrich to refute the testimony of Mr. King.
You ready?
You may testify.
Okay. I'm Sam Himmelrich, Jr., and I'm here on behalf of Utah Property Enterprise. Approximately 25 years ago, our family acquired Meadow Mill from the London Town Manufacturing Company, where they made London fog raincoats. Approximately 17 years ago, as indicated, a proposal to put up a single pole billboard occurred. Basically, what happened subsequently is this. The lease expired in the end of 2013. At that point, the lease went to a month-to-month arrangement. We discussed having digital with Clear Channel at that point, and they seemed less enthusiastic than we did. And at that point, we did apply to this board to have digital approved. But at the time, we knew that we didn't own the sign, but we also knew, we believed, that we could replace the sign with our own sign. So when we came here, we expected to have that occur, that we could probably work something out with digital, with Clear Channel. And candidly, though that application suggested existing board clearly could have meant their existing board, or it could have perhaps meant an existing board subsequently that we put up, which would be our existing board. But we really didn't when we applied for that, no. We also didn't expect that Clear Channel would object, but when we got here that day, they objected. And we really said at that point, perhaps this isn't the right route initially. So we ended up deciding to replace the existing sign with an existing sign, just like it was. We wanted to have the identical sign. So the first thing we did was we went to the city and asked for their permit drawings. They didn't have them. We even sought a search of the archives, which I think the city has a record of, and there were no drawings in the archives. Then we heard of a company that did billboards that we thought had done this billboard sign. And we actually, they are the same company that erected the sign on Charles Street, or converted that sign to digital. And that particular company, Selective Structures, put together a proposal for us for a sign and gave us a permit drawing, which we believed at that time to be identical to the sign that was there. And it was for a sign that was 65 feet tall. And we applied to the building, to the plans examining area to have this approved, and it was subsequently approved. We then waited 10 days, which is the appeal period, and we then gave Clear Channel notice that we wanted to, and we were very careful, it was a month-to-month lease, and we made it so that the month-to-month periods were accurate, and we gave them notice it would expire. I think the date was the end of October 2014. So we gave them notice of that.
Would this be a copy of that notice, Mr. Himmelrich?
Yeah, it would be.
So I'll mark this and introduce it as appellant's exhibit number 1.
So we gave them notice, and I think at some point we applied at that point or reapplied for digital, you know, on this new board. Incidentally, and this is just a small contradiction, the reason they knew that we had applied for a sign was because I told Steve Ginsburg, and maybe they found out later, but he seemed shocked when I told him that we had a permit to put up a sign. So as much as they claimed that it was from a scan, and maybe it was, and maybe the two occurred simultaneously, we called him up as part of this and said, we've gotten a permit to replace the sign with a similar sign. So we told him. We had enough correspondence, and we were not, in any case. At that point, we also sought another proposal from another sign company. Someone who we had spoken to told us of another sign company. This sign company came out to the site. Actually, before they came to the site, they claimed that they were the ones who put up the sign. And they were more convincing because they then sent us copies of the sign. At this point, we had a 65-foot sign. They sent us copies of the original, including working drawings of the sign that was erected there. And it indicated that it was 75 feet. So we knew we then had a legitimate permit, we believed, for 65 feet. And we believed that we could put up, you know, assuming we had a permit, as long as it wasn't taller than 75 feet. It was fine for us, and we had a permit to put up a 65-foot sign. We would have rather, at that point, put up a 75-foot sign, but we had a permit to put up a 65-foot sign. Incidentally, the drawings absolutely reference the weight of an LED sign. However, if one looks at the drawings, it is impossible to tell from this drawing whether it is for a static display or for a digital display, except for the notes. The structures are identical, and as it works out, the structure that was there before is just fine for a digital display. It relates to a number of the components, but all of these signs, you know, are similar. Incidentally, we got a proposal from this new sign company to put up a sign, and they sent it to us, and we said, we can't put up that sign. And they said, why not? We said, because we have a permit for a sign that is different. We said, if you want to do this project, you must change your drawing to comply with the drawings of the original selective structure drawing. And they did. So the drawing which we did, though the city has suggested is different. Incidentally, at that point in time, in the first engineers that Clear Channel has claimed should have known that were not the original engineers. The first engineers were a different engineering company than, we got the permit not from whatever the name is in Pless, but from another company. So in any case, at that point in time, we, I'd like to clarify something. When we had our permit, if one goes to Clear Channel's current leases, and we have other signs with Clear Channel, it's very explicit that they are allowed to leave the footing in the ground. So what we didn't want, ours said, incidentally, it did not, our lease did not require Clear Channel to take down the sign. It says they may take down the sign. So there was nothing that caused them, you know, to do it. So we just wanted to clarify that if they did take the sign, they kind of had two options. Either take the whole thing, including the footing, in which case the footing wouldn't be in the way because you're only allowed to relocate it within 10 feet, or alternatively, leave it, including the bolts. We got the engineers who originally designed that sign in conjunction with a local geotechnical engineer, Dave Kazera, to approve reusing that footing. And had they taken it, that would have been fine, taking it out. But we viewed removal of the sign as not being, you're allowed to take down the pole and then do a scorched earth one so that we have to get rid of the rest of the carcass, but rather, if you want to do it, either of these options work. You either, take the sign without the footing or take the footing. But if you leave the footing, we really want the drawings of the footing. We thought that was a totally reasonable request. They claim that the lease didn't allow us to do that. But in any case, so at that point, we decided to proceed putting up a sign, and we did. We took down their sign in exactly the same manner they would have it. We unbolted it. We put it on the property. We got 2 proposals so that, we mobilized the crane to do it. And we put up a new sign, which was 65 feet, which we believed we had a permit to do. Subsequently, we received, Clear Channel went to the city and said it isn't right. Incidentally, one of the other things that's been suggested is that our original permit drawing doesn't have the same footing, and that it suggests it's a deep auger footing. If you look more carefully, you'll see that there are 2 footing styles suggested. One is a deep auger. This is technical stuff. I apologize. And the other is a cube or form of spread footing. And it also says that if the soil conditions are different, and they are, we have a lot of groundwater as a result of the Jones Falls there, consult the engineer, and we did. So I would argue that we did it consistently with that. We knew we didn't have a permit for a digital sign. The concept that we were trying to do the end around or act circuitously in order to erect a digital sign is candidly ridiculous. And I think Clear Channel knows that, but they seem to continue to make that argument.
Mr. Himovich, you're familiar with, may I just borrow these?
Which one?
The one right there, the 29.99.
Actually, I think it's my copy. Let me.
Oh, I'm sorry. I apologize.
I just wanted to make sure that you were. Here you go. I'll turn to yours.
Thank you.
Okay. Then I want to speak about the lockbox payment as well. Okay. You want me to speak to that first?
Yes, why don't you speak to the lockbox
Okay.
payment?
Essentially, in November, after we had terminated the lease, we received money to a lockbox. We use SunTrust for collections, and it goes to a lockbox. So at the point at which we received notice that the check was received, it had been deposited. So we actually issued a check, called them, because and wrote them a letter, and we have a copy of the letter that said, we received November's check, obviously in error. We're thrilled to return it. And then we said, alternatively, so the original arrangement with Clear Channel involved percentage rent. So we were highly likely to receive more money subsequently. And we threw out the option of we'll hold it and apply it against it. But we offered to return it. And it's impossible. It's like unringing a bell. We had received it. The bank automatically deposits it. Within a week, we had said to them, look, we got this check. It was an error. And then, subsequent, they wrote us another check. As it works out, incidentally, at this point, we have reconciled with them and paid. They have sent us in the last week a reconciliation. We've checked it. We disagree a little bit about what they're paying, but the amounts are identical. We agree totally with them about the amounts. So I would say there's no argument that money which was due as a part of our past lease arrangement is due, and whether it was paid as November rent or percentage rent, we got what we received and they paid us. So we've no, our argument does not go to, they're not living up to that end of their arrangement.
Now, Mr. Himovich, you're familiar with what is Appellant's Exhibit number 4, which is the 249.99X opinion or resolution issued in 1999 by the BMZA.
I am.
And it allows a billboard sign to be erected at the property 3600 Clipper Mill Road. Is that correct?
It does.
Okay. And it specifically addresses that the property where the billboard should be erected is 3600 Clipper Mill Road.
It does.
Okay. And what's allowed there is a sign that has a height of, limited to 75 feet, is that correct?
It is.
And that's on page 4 of Exhibit 4. And secondly, it says that the face shall be 14 by 48, is that correct?
That's correct.
And there shall be no tri-vision without further BMZA action, is that correct?
That's correct.
And in fact, you never sought to erect a tri-vision sign at any time except pursuant to the current application you have pursuant to this board,
That is correct.
before this board.
That's right.
So the 75-foot sign that was erected on the site would in fact fall within the parameters of exhibit number 4, which is 249.
I'll object for the same reason.
44F.
Mr. Sheriff objected, Mr. King making legal conclusions.
Well, I think that the document sort of speaks for itself, though. One thing I would point out is that continuing on to page 5, it does state that no changes are to be made in the size of the proposed sign, and that any changes to the size, lighting, or other physical elements of the sign may not be made without BMZA approval at a public hearing.
Well, Mr. Hemmerich, the limitation on page 4 of the sign, it says, number 1, the height of the proposed sign will be limited to 75 feet, is that correct?
Yes.
So, you were, in changing the sign to 65 feet, you were in fact within a limit of 75 feet, is that correct?
We were.
So a 75-foot sign complies with 249-99X, and a 65-foot sign would comply with it as well.
Again, I make the same objection for the same reason, for the record.
Well, the witness's understanding, I think, has some relevance.
That's correct, Mr. You may answer.
That's correct. And, yeah, let me also point out that we really did want the sign to be the same. We really, the 65-foot routine, if you will, was nothing that we tried to do. It was just that the vendor who we sought a proposal from didn't represent correctly what was there. I think they made a mistake.
Okay. Now, exhibit number 5 to the, or appellant's exhibit number 5, to the, which is attached to the memorandum dated March 10, or March 20, dated February 27 for March 10, is a permit, the actual permit for the erection of the sign at 3600 Clipper Mill Road in 1999. Isn't that correct?
Yes.
And to whom is listed as the owner on that permit?
Samuel K. Himmelrich, general partner of Utah Property.
Yes, who is Samuel K. Himmelrich, general partner?
In that case, it's my father.
And he was a general partner of Utah Property.
He was.
And how is P&E Media, this predecessor to CCO, listed in that permit?
As the prime contractor.
And not as the owner?
No, not as the owner.
Other than that, at this point, Your Honor, other than presenting Mr. Barry to testify with respect to the LED conversion that we seek here today as well, which, because there was no LED conversion, we seek an LED conversion here today. I would have argument with respect to the ownership of the non-conforming use and with respect to the abandonment.
Okay.
So with respect to the issue of the ownership of the sign and the non-conforming use being the sign that was at the property, as we said in our memorandum, there's at least 4 reasons why the non-conforming use is owned by the owner of Utah Properties. First of all, the resolution 249-99X, as Mr. Himmelrich has just pointed out, says that the property on which the billboard is to be erected is 3600 Clipper Mill. That is owned, in fact, by Utah Property. Secondly, the permit to erect the sign, which was just introduced into evidence, or introduced earlier into evidence, which Mr. Himmelrich just testified about, also clearly identifies Samuel K. Himmelrich as the general partner of Utah Properties as the owner of the property. So the permit was issued, in fact, to the owner. It wasn't issued to CCO. CCO was merely the prime contractor.
Okay, go
ahead. And in fact, this conclusion is completely consistent with the only precedent we could find in this by virtue of decisions issued by this board, which was the North Howard Street case, which says that the nonconforming use belongs to a property owner, and only the property owner may abandon the sign or abandon the nonconforming use. And in fact, that was a sign case. And in fact, the BMZA at that point found that the effort to obtain a permit to erect a new sign was not abandonment, did not constitute abandonment, and found that the owner did not in fact abandon the sign. Now, that is consistent with the seminal case on point from the Court of Appeals in this case is the Castendine versus Bark case, where the Court of Appeals, not the Court of Special Appeals, but the Court of Appeals has held very clearly that a nonconforming use runs with the property. And in addition to that, that all makes perfectly logical sense for the simple reason that 11502 clearly anticipates that billboard signs are going to be replaced, can be replaced, as long as there is no increase in the billboard sign, whether it be increase in lighting, whether it be increase in size. And 11506 allows this board to make certain findings with respect to the movement of a billboard sign. So clearly, the statutory framework allows and anticipates that a sign will be taken down and a sign will be put up, and that in 11506, clearly the sign and the nonconforming use belongs to the property owner because only the property owner can move that sign by 10 feet. The sign owner can't move it by 10 feet. The property that's leased is not necessarily that 10 feet. So necessarily the property owner must be the one who owns a nonconforming use with the ability to move the sign. As I pointed out earlier, the Up-to-Date Laundry case has absolutely nothing whatsoever to do with any of this. And the fact is that the Up-to-Date Laundry case has only something to do with illegal zoning. So that was the holding of the reported case. It didn't have anything to do with non-conforming use ownership.
Hi.
Mr. Hemmerich, would you like to interrupt me? Go ahead.
No, I just wanted to point something out because I'll forget it if I don't.
So go ahead, please do.
Okay, and it relates to the issue as you do this of demolition. First of all, we received a permit for a sign at a height which we believed to be an exact replacement. We were wrong. But at the time, we believed that it was a 65-foot sign. The permit said to replace. Okay, we had to take down the sign, and we've heard we didn't issue a demo permit. We're in the real estate business, and we do construction and demolition from time to time. What we did, in my opinion, was not demolition. In fact, they've shown you a picture of the sign. We essentially dismounted and removed it from its base, but it remains actually still on the property. It could be re-erected. So I think the term demolition and a demo permit, you know, as well as the suggestion that they, incidentally, their demo permit occurred after we had the permit to replace, which I think by definition involves take it down and put it up. So
I was going to ask you, Mr. Hemmerich, in fact, the permit, which is Exhibit 7 to the February 27th memorandum, doesn't say demolition, does it? It says replace existing sign billboard.
Right. I would argue that replace means take down and put up a new, you know, sign, and that it isn't explicit, but I also would argue that it's not demolition. Demolition usually, though not always, renders the removal useless. And I think we didn't demolish the sign. We took down their sign. We acknowledged that it was theirs. We sought their reimbursement for the cost of taking it down if they wanted it, and gave them the option of calling it abandoned property otherwise. And these are bold folks, so it isn't like they couldn't have come to us and said, well, you know, we don't like that. But in any case, we asked them to pay us for our cost of taking it down.
And with respect to the issue of abandonment, Mr. Chairman, I think you're absolutely right. You're right on point by saying, isn't there the effort to get a valid replacement permit showing that, in fact, there was no intention to abandon the sign, consistent with the North Howard Street case? The fact is, the matter is, my client sought to get a sign permit, a replacement permit, to put up a new sign. In addition to that, they are here today pursuing the change of that sign, or the existence of that sign, and then the change of that sign to a LED sign. So there have been nothing but efforts to maintain the use of the property and not to abandon the non-conforming use. Simply taking down the sign is something that is clearly anticipated by 11502 and 11506. And 11502 and 11506 never say, oh, and only the existing sign owner, only the entity that owns that physical structure can take it down. And clearly, what's happened here is that CCO is seeking, as I said earlier, to control from the grave the fact of the matter that they can't possibly operate on this property any longer and put up a sign, a billboard sign. What they're essentially saying is that we're taking out of your bundle of rights the stick of the ability to utilize this property for the non-conforming use of a sign. We're taking away fundamental ownership rights from this property owner to say that though we don't have a lease, though we have no interest whatsoever in this property, we can tell you only we have the right to put up a sign. Only we have the right to control the billboard sign. I respectfully submit that based upon the Castendine decision and this board's own decision, very logical own decision in North Howard Street, that simply is not the law. They can't walk away from the property. They can't fail to renew their lease, have the lease go to a month to month, have the lease then terminate on October 31st, and then say, oh no, only we can put up the sign. We own the sign structure, and though you own the land, you can't possibly put up a sign. That is turning the law of ownership of real property on its head, and cannot possibly be the result that this board would want to uphold today.
Okay. Anything?
Nothing further.
Mr. Woolman?
Except in terms of the case, of the conversion to LED case, I'm not sure how we're proceeding here. Should I call Mr.? Or do you want to do that after?
Address the threshold issues, kind of batting those around enough.
Let me give this back to you. Is this mine, Joe? Yeah, it is.
Very briefly, Mr. Chairman, with regard to the case cited by Mr. Scher at the Castendike, we're talking about a completely different type of use. I believe it was a nightclub in Castendike, and again, that's analogous to the point I made earlier. If you had an industrial building that had a conditional use for an office, I mean, they're completely not on point to the issue here. Again, the unique aspect of the use of a billboard structure really speaks loudly to this case. I don't believe the case cited by Mr. Scher is dispositive in any way regarding this matter. And more importantly, and Mr. Chairman, you pointed it out, the 1990 BMZA decision clearly stated that if you were going to make any changes to this sign, you had to come to the board, to this board, to get the approval to do so. And Mr. Himmelrich knew that. He came to this board in February of 2014 and applied to do just that.
That the language in that opinion, couldn't that be seen as being somewhat ambiguous as to whether or not, I mean, when you look at what is provided in the code, it talks about, if I can flip to it, this is in 11502. It says that any non-conforming sign may be structurally altered, replaced, or relocated as long as the alteration, reconstruction, replacement, or relocation does not result in an increase in the area or any dimension of the sign, and an increase in degree of illumination, in addition, the retention of moving, rotating, or otherwise animated part, or flashing, blinking, blah, 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 blah. Isn't that language there really just sort of looping in the provisions of 11502 there, that that what's being sought in the language of the opinion or of the decision says, you know, it really speaks in terms of maximums. I mean, even if you go through it, I mean, it's talking about the square footage shall not exceed this much, and it really talks about the the outer limits of what's being permitted, and then it would appear to give some ability to reduce, but not enlarge, beyond what's being approved. And then if there's going to be any enlargement, then that language could be seen as just being a reference to what's provided in the code. I hear your argument as far as the understanding that that language could be also read to be an absolute strict locking in place of what's being approved, but couldn't it also be seen as just simply referring to the other parts of the code?
I think the chairman's point would be stronger, but for also the moratorium that is at issue here regarding billboards and the conditional use aspect of converting to digital. There are other sections in the code that refer to you can't change an existing conditional use without coming before the board. You can't change to digital without coming before the board. Yet that's exactly, and I understand people are not happy with my use of the word end around, but I don't know what else to call it when you recognize that issue. You apply to this board. You come here in April to ask just for that because the law requires it. That case is postponed. Negotiations break down between the parties, and then you go and apply online to do the same thing. That's the issue I take with the quote-unquote end around. In addition, and I think this is interesting, and I don't know if I caught Mr. Tanner raising his eyebrow when this was testified to earlier or not. I thought maybe I did. The 1999 approval also requires the removal of the rooftop sign. And that sign's still there. So that's yet another issue regarding the 1999 approval that wasn't a condition that was not met in terms of placing a sign. Again, our position is that there cannot be, once this sign was torn down, another sign could not go up. Once it was torn down without Clear Channel's authorization, if we're to take Your Honor's interpretation of the code being more of a general statement, then Clear Channel wouldn't have to have applied for all those conversions that it applied for in the binding.
No. Because what was being applied for in that in the 99 case was a erection of a static billboard, and there was a limitation there as far as that if there was to be any conversion to the Trivision board, that would have to come back to the board. But I mean, as far as that condition number 5, that is that any changes to the size have to come to the board. My question is whether or not that language is somewhat ambiguous in light of the fact that the code requires that when you're dealing with enlargements, that you can't do that. But if you're making something smaller, that would seem to be permitted under the code, which could also be understood as making some amount of sense because you're making something that may be an issue at one size, less of an issue like making it a smaller size.
I understand, and I'm pleased that the chairman recognizes that there's the additional issue of changing to digital and changing the conditional use and having to come to the board to do that.
Yeah, and that's a separate issue. I'm just talking about the portion of the case just dealing with changing the size of the sign. And that goes back to the language of that the 99 case.
Understood. I'll submit it this morning, Mr. Chairman.
Okay.
Just a few things, Mr. Chairman. The fact of the matter is that all the evidence introduced earlier is irrelevant to the concepts that I just argued with respect to what the law provides in 11502 and 11506 and what the cases provide. I pointed out that the Castantine case is not some nightclub case. And maybe Mr. Wall was not old enough to remember the Baltimore Association for Retarded Citizens, but that's the case. What the case found is that a hospital or a nursing home at that site could be converted with a non-conforming use to a Baltimore Association for Retarded Citizens home, right in Roland Park. So I don't think it's irrelevant at all. I think that it's a very relevant case, and even if it were a nightclub, it would still be relevant. But the fact of the matter is that it doesn't change that 11502 and 11506 sanction the removal of the nonconforming use and the putting back of the nonconforming use. While there is a presumption in favor of not having signs, there is a so-called moratorium. There is a provision in the code that allows signs to, nonconforming signs to be replaced. And finally, with respect to the removal of the existing sign, I would point out that the general contractor was CCO or its predecessor. It failed to remove the sign, not my client.
Yeah, and the lease, and the nature of the arrangement and the lease was that it was to be required, was to be removed as part of the arrangement by them. So it's kind of interesting that now they're claiming it wasn't done when indeed it was an obligation of theirs during the period of the lease. And arguably, that the structure which remains, if you look at their picture, it's interesting. You really see the trees beyond because the boards which were once on it aren't there. So arguably, the sign isn't there anyway, but I'm not here to argue whether the structure is or isn't the sign.
Okay, thank you.
That's all.
All right. We'll deliberate on the motion to dismiss. Yeah, I think it's a pretty simple point.
I don't, once the lease terminated, I don't see how the CCO had the ability to sue and after they lost interest in, as a lost the lease, interest in the property.
And then would the real property owner be eligible? I mean, I think that CCO's position is that the only person who can pursue the conditional, any change of the conditional use, or the only person who basically controls it is the operator of the use. And so once they go away, the ability to use it goes away. My thought on that is just simply that it's kind of one of the basic elements of real property that you're all talking about. One of the primary rights that are involved in the ownership of property is the right to use it. And I don't know that that gets conveyed forever as part of a lease when there's, with the conditional use. Yeah, I don't think that we view that with cell phone towers. If we got any number of those cell phone cases, and if Verizon, we want to put up a pole, and then if that lease expires, can the city not go with AT&T?
I think you gotta go with the real property owner.
Yeah. I think that the power to really regulate this anyway goes with the real property. I don't know that we've got the power to go sort of beyond that. So I think that there could be an element of an argument at that point if you're saying that that right gets taken away from the property owner, and it can only be pursued by the fixture owner.
It doesn't, I agree, it doesn't make sense. Basically,
my sense is to, unless we're going to deliberate anymore, I'm going to vote to deny the motion.
I agree. The motion to dismiss?
Yes.
Yes.
Oh, that's right. There's two motions. The other motion, and I think that this really is sort of determined by the result of the resolution of the motion to dismiss. The other motion is, so there is the appeal, the substantive appeal, is to replace the building. And Clear Channel is objected as the putative owner of the use. Utah says that Clear Channel has no standing to really participate in the case. I mean, we don't really, strictly speaking, we don't really determine standing at this level. So I don't know that there's any, because it's really seen in so many different areas where people may have remote connections to appeals, but we still hear their positions. Utah's position is that Clear Channel shouldn't be able to participate in the substantive appeal because they don't have an interest anymore. I would be somewhat, I would be somewhat uncomfortable granting that. Yeah, I see the point, but we don't. I mean, how many times do we have cases here and people say, "Oh, this person should be heard because they don't have an interest in development"? We still let them participate.
A lot.
Yeah.
When you get back to the, casino, I mean, there's people that we certainly have questions about whether they had standing to object. And,
Yeah.
we'll let them be heard.
Yeah. So I think that that should be, I mean, I hear the point, but I think that was just simple as we go.
I don't think it's going to preclude us from deciding going into
Yeah,
other
I agree.
issues that are before us, so.
All right.
Mr. Chairman, if I may, and I apologize if this is out of order, but should the board consider hearing from the city before finally ruling on whether it can proceed, considering the city's going to testify about whether or not the sign exists legally at this juncture?
That issue, that's an issue that I am considering. As far as this point in the proceedings, we've heard argument extensively now for a couple hours on the motions to dismiss, and we deliberated on that, and I should say that it's really on both motions to dismiss. That is Clear Channel's motion to dismiss Appeal 2014-64 for the premise that Utah does not have standing to pursue that appeal because they're not the owners of the fixtures involved, and the code requires approval of the property owner, and Clear Channel asserts that it's the property owner. That motion we're going to deny, and you can kind of don't really need to go too much into the reasons for that. Suffice it to say that the board differs with the construction of the code argued by Clear Channel. On the motion made by Utah as far as Clear Channel's standing to object to appeal number 2014-64, that's an argument which we see as being taken on standing grounds. That is, that since Clear Channel no longer owns an interest in the property, they don't have a sufficient enough, for lack of a better phrase, dog in the fight to object, because any objection is just simply made for competitive reasons and not for any interest in the property that's there. Although that may be an interest or an argument that may be pursued on appeal, it's typically not one which we address at this stage. So that motion is going to be denied as well. Now, that gets us to the underlying appeal, and the other thing that we have pending also is the issue of revocation. I do think that there is some interplay there. Where that ultimately concludes, I think we can sort of shake that out. But since the appeals are being heard on a consolidated basis, I think that the way to proceed at this point, particularly Mr. Sheriff, since I think we've heard significantly as far as what is being proposed, and it's a fairly straightforward proposal, I think that we can hear appeal number 2015-25, and the city can be heard on that and the issues involved in the revocation, because I think that those issues may come to bear as far as whether or not what's being sought in 2014-64 can be granted, and then you can respond to those issues, and I think we should be done at that point. Okay. All right, Ms. Byrne and Mr. Veal. All right, we're going to take a 3-minute break. Off the record. Fund and state the city's position.
Okay. When I have to go a little shorter here. The city's position, we're here based on the revocation. The city revoked permit number COM 2014-14737 based on plan number 2014-1347 to replace an existing billboard. Going back, I submitted a letter dated February 27th, which basically gave sign permit chronology from what the city had. As has already been previously stated and submitted to the board, August 12th, 1999 is when the original approval came from the BMZA for the existing structure to be, freestanding structure to be built on site. We issued a permit in September 28th, 1999, to remove the existing rooftop sign, construct 2 general advertising signs on a single pole, 75 feet in height, 14 feet wide by 48 feet. Then the owner, based on the permit that I just referenced, submitted his application to replace that existing sign on July 15, 2014. We issued the permit on August 21st, 2014. I believe you have in the file was previously submitted by the city via the February 27th letter, and I believe Mr. Woolman has also submitted a copy of the drawings, which were submitted to the city and approved by the city, and ultimately issued. The plans did indicate LED on the lighting and identified the sign height as 65 feet. When a permit application comes into the city, we rely on the applicant to provide information. Mr. Himmelrich testified that he tried to look into city archives to get a copy of the actual drawings. At some point over the years, the city uploaded plans and permits. That particular plan was missing, so the city wasn't able to verify the 65-foot height and took the applicant at its word that the 65 feet height was a replacement in kind of what already was there and existed. There were references to LED. Just to clarify, when a permit application comes in and it involves a structure, we now have something called E-plans. It's been in place for a couple of years now, that when you submit engineered drawings, it's done electronically and submitted online. I don't think I was sworn, and I don't think Mr. Veal was sworn, but I think I'm just proffering, so would you want to do that later?
We normally don't have
City
counsel
right.
be
Testify.
sworn, but if Mr. Veal were to testify, he'd be sworn.
Okay, and if I say anything incorrect, Mr. Veal has been directed to nudge me and correct me, and we'll go from there. So when a permit application comes in and it's submitted electronically, it goes into one gatekeeper, Gancham Patel, who is the plans examining director, and then it's farmed out to the varying reviewing boards. So Mr. Veal is the last one out as far as reviewing the permit application to make sure that the zoning is proper. Planning reviews it, sometimes DPW reviews it. It all depends on what's required. In this particular instance, the application went to planning. Planning made an electronic note that said it's okay with them, replacement in kind, so long as there's no LED. When we issued the permit application, it stated replace existing billboard, but it didn't say anything about LED. When it was brought to our attention that when you look at the plans, it did anticipate LED, it looked at notes and scope. That's when we made a determination. We spoke with the applicant.
One moment.
Sure.
Do we have, it was an exhibit in the motions argument, the plans that were approved, it was big. You can see those from us. Thank you. No, the large exhibit that was passed up as, or was it?
That's it.
Part of this? Okay.
Mhm.
All right.
That's it, and I believe Mr. Woolman also submitted it, but his might have been bigger. I'm not
Okay.
sure.
And if I'm getting your reference correct, I guess in the middle of the plans, it says, note, this unit has been designed to support 2 LED units weighing approximately, I think it's 9,000 pounds, 9,072 pounds each. LED and LED attachments are designed by others. Supports must be mounted within 18 inches of, if not directly to, the uprights. Is that the
Correct.
reference you're? Okay.
There are other additional scattered LED references, I believe in the general notes, there was some additional references to LED. So when it was brought to our attention, we contacted the applicant, had a conversation with Mr. Berry, said it was not their intention to put LED up at this time, and that all they were seeking to do was replace an existing billboard. So that's when the city issued a letter of clarification on October 22nd, 2014, that it was, the permit issued was restricted as a replacement in kind only, no LED approval granted. And in theory, the note from planning that said no LED should have made it to the front of the permit application, and it did not. So we, at the time the permit was issued, that statement should have been on the permit, and it wasn't, which is why we issued the letter of clarification. So it was, there was no misunderstanding that LED was not approved. It was strictly a replacement in kind.
Okay. And that was an attempt to hold the applicant to their representation or representation through their consultant that there was no intention to do LED on the sign at that time.
Correct.
All right.
Well, early December, the property owner removed the existing sign and constructed a sign at 65 feet in height. An inspector went out and reviewed the permit application that we had on file, reviewed what was built, and visually saw that it was not a replacement in kind, issued a stop work order, raised a number of issues with the drawings and what was actually constructed on site. So it was at that point.
And what was, do we have, is there a record of what was visually observed as being not in conformance with what had been approved?
I believe Mr. Woolman put in the notice of violation and a copy of the stop work with his documents.
I think that might be correct. One moment. Can we find that, David? It was one of the exhibits. I remember there's being a violation letter.
But still, at that point, we just had the stop work. The permit was not revoked at that point yet.
Okay.
So that's separate from,
And was there, maybe we will, maybe we can sort this out when we find the exhibit, but was there, I guess the concerns that were noted at that time, did they go to the issue of LED, or were they to some other issue?
it was more the nuts and bolts that what was constructed on site didn't match up with the permit application. So it was more a construction end.
Okay.
At that time, we still didn't know that 65 feet was not the replacement height. And I think Mr. Hemmerich even testified himself that he believed that the original replacement was 65. The city continued to rely on that belief and had no reason at that time to believe that it wasn't 65 feet until the inspector came back and said, this is not the same height, it's not the same size, but he focused more, I believe, on the nuts and bolts.
Okay.
But that's, again, not the basis for the revocation.
Okay.
But that's when it was first brought to the city's attention that something might not be right.
Okay. All right, continue.
Okay. So it was, the applicant was very forthcoming. They provided us as-built construction drawings, and then when we realized it didn't match up with the original permit application, we asked for additional engineer certification regarding construction and materials used. Again, the way that it works is we rely on the certifications from the outside engineers in order for plans examining to make a determination as to the permit that they're issuing, that it's sound. It was explained to me that, you know, even a slight difference in height or adjustment can make a huge difference on the engineering of a sign. So the applicant provided to us copies of as-built and engineer certification that the structure itself was sound. It was shortly after there that we realized that a copy of the original application or a copy of the stamped permit, which we did not have in our file, indicated that the height was 75 feet and not 65 feet. So the city on January 16th, 2015 revoked the permit that the property owner was issued. This was after the billboard was constructed at 65 feet in height. The applicant believed he had the authority to do that. At the time we issued the permit, we believed we had the authority. We believed we were issuing a replacement in kind. But when under the building code, there's a section in the building code, subsection 105.6, that says that if a permit was issued in error or based on incorrect, inaccurate, or incomplete information, the city can either suspend or revoke the permit. And the bottom line is, when we figured out that it wasn't 75 feet, that it was 65 feet, the zoning administrator doesn't have, it's always been our interpretation, doesn't have the ability under the zoning code to allow a change in a non-conforming general advertising sign, and therefore the building official could not have issued the permit because the zoning administrator could not legally sign off on a height of 65 feet versus 75 feet. And that's one of the reasons why the permit was revoked.
Okay. And you said that that's based upon sort of an internal understanding of the provisions of the zoning code that the zoning administrator has?
Right. The way that like as I said, when a permit comes in, is scattered basically to the four winds of review, right? And then it comes back. The last person who signs off and reviews it is the zoning administrator. And the zoning administrator would make a determination as to whether the use proposed is legal underneath the code. At that point, if Mr. Veal knew that the original height of the sign was 75 feet and what was being proposed was 65 feet, he would have denied the issuance of the permit and sent the applicant to the board to ask the board to change, that they were seeking a change in the approved non-conforming use.
Okay. And that's an understanding that the zoning administrator, do you need to refer to Mr. Veal for an answer on this? That's understandable. But that's an understanding within the zoning administrator's office, even if the discrepancy is one which makes something smaller as opposed to bigger. I mean, here, I think the effect was that it lowered the height of the sign,
right,
75 feet, I mean by 10 feet, so that it wasn't up as high.
Right.
I'm going to presume that that would make it less visually intrusive because it's closer to the building envelope than it had been previously.
Well, it all depends on your interpretation. In this instance, the sign is off of 83, so dropping it down 10 feet brings it closer to 83. Does that have a bigger impact on the driver or not? I don't know. There are some that would say that the building official and the zoning administrator don't have the ability to issue even a replacement in kind, that's that's too broad an interpretation of the building official and the zoning administrator's authority under a non-conforming general advertising sign. The way that the zoning administrator and the building official have interpreted changes to non-conforming uses or non-conforming general advertising signs has been, and this has been pretty consistent, Mr. Beal, please correct me if I'm wrong, is that if it's exactly the way that it was before, we can issue you a building permit. The zoning administrator is not overstepping his bounds, not doing something that the BMZA is charged with. If there is any change in that non-conforming use, it's up to the board to make a determination as to whether is that change more intensive, less intensive. That has been the interpretation of the building official and the zoning administrator. So in this instance, it was the building official and the zoning administrator's determination that they did not have the legal authority to issue the permit at 65 feet, which is why it had to be revoked and referred to this board. So, Mr. Beal, want to jump in and say if I...
There you go.
You solemnly swear or affirm under the penalties of perjury that the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes. I just want to echo Ms. Burns' statements, and she's right on target with it. We believe that the initial permit that was issued was indeed and in fact a replacement in kind. You were replacing the existing sign, just like the permit says. It says same size and location. The presumption is on our part that what you're replacing is what was there before, that it was 65 feet high and the sign faces are exactly the same as what was approved and what was put up. And by their own admission, that is not what was done. It was not 75. It's if the sign was reduced in size, then it's not a replacement in kind. And that change, we believe, needs to be approved by the board. I don't think I have the discretion to allow a change in the height, and the whole argument as to whether or not there's any more of a deleterious impact based on lowering the height of the sign. I think that's a decision that the board can make. All we did in initially issuing this permit is on the presumption that whatever you were going to put back was what you had there before, and that's not what they did.
And had it come to your attention how that discrepancy was came to be, and I think that Mr. Himmelwitz testified that that they'd gone to the prior contractor who they thought was the prior contractor who had drawings that indicated that the height was at 65 feet, and that they'd looked through the plans that the city had and they weren't able to locate it, so then they had to go find the contractor, and they thought that they had found the right one, and it turned out not to be the right one. Had any of that come to your attention before today at all?
No.
Okay. All right. And then the question I have for you, Ms. Byrne, is if the board were to uphold the revocation of the permit, what would be your understanding of the impact of that vis-a-vis the application to remove and replace the billboard, which is what's sought in the companion appeal?
Well, I think the board would have to make so if you upheld the fact that, if you believe that we revoked the permit properly, then the question is, if what they have there now, can it exist, right? From a nuts and bolts perspective, that's easy. We can, a permit application can be submitted to make sure that the structure is right and correct and meets the minimum requirements under the code. As far as the height, that's still a question for the board to decide. So we revoked it because we believe that the board had to make a decision. So it's up to the board as to whether or not the non-conforming use can be altered, and what, if any, impact the revocation had on that.
Well, if I understood what was said in the motion argument, I think what the intention of the applicant was to put up what was there before,
Mhm.
which is to say a 75-foot sign. And they
Right.
built it at 65 feet kind of by accident.
Right.
So if they were to seek to build it at 75 feet, I'm not sure that the board would have anything to consider at that point as far as 75 versus 65. It's just a question of, can they have what was there before, and can it be LED versus static?
Right.
All right. You can continue.
And that's pretty much it. I mean, that's our case in a nutshell, is that we believed we didn't have, when everything was fleshed out and we realized the height was wrong and that the building official and the zoning administrator didn't have the ability to issue the permit to begin with, under the building code, we had to revoke because we overstepped our bounds. So at this point, the permit, it's still alive because there's an appeal of the revocation, and there was a timely appeal of the revocation. So the board now has to make a decision, did we properly revoke? And then what happens after that really is up to the applicant and up to the board.
Are there any statutory options other than revoke or suspend the permit in a situation like this?
Not coming here. When the board is involved, we can't, there's no real discretion. Nuts and bolts, we allow people to amend many, on a regular basis for nuts and bolts issues. There have been times where, but we do revoke, so.
But you can amend it.
You can amend.
It's within your power.
It is within our power to amend, but because we believed that the board had to make the determination on whether or not 65 feet was okay.
Yeah, I understand that.
That was the reason we had to
just wanna
revoke.
see it, okay.
Yeah, so we do allow applicants to amend, and when they amend, right, it's a take back and a reissue.
Mm-hmm.
So it's a do-over.
So what would have happened if, as I said, as I understand the course of events here, it was built at 65 feet by accident.
Mhm.
If the applicant had said, you're right, it's at 65 feet, it's, the plans show that it used to be at 75 feet, let's amend what we filed to have it at 75 feet, and we'll, if it's already up there, we'll put it up at 75 feet. Would that have been something that could have been accomplished at that point?
The cat was kind of already out of the bag, so that's one of the reasons that we revoked as far as the sign being up. I mean, that's really a question for the building official, who I can't speak on necessarily on his behalf. But it's this zoning piece that we couldn't really wrap our arms around to allow the permit to be amended.
All right, thank you. Unless you had anything for.
Sure.
Sure.
Oh, sorry.
You use the phrase "in kind" a lot.
Mm-hmm.
It seems that the criteria that you really set forth is replacement in kind. Under 11502, is the words "in kind" are the words "in kind" used in that section?
502, I do not believe that exact language has been used, no.
And in fact,
Well, you know, Jeff,
502.
I probably shouldn't answer, probably should be.
Yeah, I was going to
should
say,
be
I think
Jeff.
that your
Right.
question should be directed towards the witness and to the advocate.
Okay, and Mr. Beal.
Yes, sir.
In a completely non-threatening, completely unintentional cross-examination, just simply want to understand. Just simply want to understand, not to in any way take you on. In 11502, it says that there are permitted alterations, replacements, and relocations with respect to billboard signs.
Right.
In that section, the criteria that Ms. Byrne and you have mentioned with respect to in kind, is that phrase in kind used in 11502?
The words "in kind" are not in 11-502.
And to go one step further, in fact, it talks about not increasing the area, not increasing the degree of illumination, right, or any other increase in the degree of the sign's nonconformity. Is that correct?
That's correct.
question for Ms. Byrne, just so that I'm clear. So, as a matter of interpretation, are you saying that in-kind is essentially synonymous with identical except for nuts and bolts kind of issues with respect to the sign?
Right, exactly, because the original sign was built in 1999, we have a new building code, so, you know, it's conceivable that there are changes to the building code that if you were gonna replace it, you'd have to bring it up to code. So as far as size, shape, location, mechanics, the picture in your mind of what it looks like today is what should be there now. If there's changes in the engineering, the structure, or code requirements that you have to bring up to date to the 2012 code versus the whatever code we had in place then, whether it was a 98 or 99, that, you know, the permit application would reflect today's code. But the sign itself, the structure itself, as originally permitted by the city in 99 and approved by the board in 99, would be the replacement in kind.
And you probably already answered this question, I believe, but the language in the 99 permit that says limited to 75 feet, was that, I mean, I take it that was the limited to was not considered as a policy decision, I guess.
Yeah, I think, Mr. Beal, do you want to chime in on that?
I think in my view, the long and the short of it is this. This decision that was rendered in 1999 authorized them to build something, which they built. Notwithstanding the other arguments that have been raised, someone applied for a permit, and it says it right here, to replace existing billboard, and it says here, same size and location, as per plans which were submitted, and per code.
Could that be a reference to the physical dimensions of the sign itself as opposed to the height of the pole on which the sign was affixed?
I think the assumption here is that this permit that we authorized initially was to allow them to replace that non-conforming sign with a new sign at the same height and dimension that was originally approved and erected per the permit that was issued. And that there was a difference between that old sign and the new sign. And the one definitive feature that distinguishes one from the other is the height.
At the time, let me just ask you for a minute. At the time that you approved the permit, you didn't know the height of the sign.
That's correct.
And it wasn't until after the sign was built that you later discovered, and I believe Mr. Klein testified that they in fact gave you the plans and show that we were 10 feet short of 75 feet.
That's correct.
So when the permit was issued, we didn't know it was 75 feet, neither did you guys.
That's correct. That's absolutely right.
Can I make a distinction? And this is not, when we applied for it, we thought it was identical in terms of location, size, and height. But there's no question that in the billboard industry, as I think Mr. King will tell you, there are three things they talk about. Location is where it appears typically on a plan view. Size is the size of the billboards, and height, which is not in this, is actually a different thing. But I'm not here to tell you that at the time we applied, we understood that distinction. The other thing which I want to clarify is on this final permit, and this is a little bit of contention, there's a difference between an LED sign and LED lighting on a static sign. And I'm concerned that in this last review, the last drawing which they're referencing, our as-built drawing, suggests that it had LED lamps, if you will, light fixtures like you'd buy for your house at Home Depot, as opposed to LED like on a TV screen. And LED light-emitting diode is a technology used in both of those. And indeed, the drawings, the last drawing which we gave as an as-built says LED, but it's referencing the illumination of the static display, not of the billboard itself.
Okay.
So I just want to make that clarification.
I also have a clarification that, I don't know if it'll help, but in the 99 appeal, the original
application requested a 100-foot high sign.
That's right.
Due to the process working through planning and the community concern, the applicant amended the application to erect a double-faced freestanding general sign, 14 by 48 feet, with a maximum of 3 feet between each face, with a maximum height of 75 feet. So that was part of the negotiation through the process of the original application. At first asked for 100 feet, and it got reduced to 75 maximum height. I don't know if that helps, but I just wanted to clarify how the 75-foot limit was created.
That would be our point, and I also believe that Mr. King, what I understood from his questions, is making the same point. That we thought we could build up to a limit of 75 feet. It didn't say you couldn't build 70 feet or 60 feet. Indeed, in one of the exhibits that Mr. Woolman submitted, the application to take the sign down, to remove the sign by his client, says, and if I can find the exhibit I referred you to, but it says approximately 60 feet tall. So even CCO thought this sign was a whole lot less than 75.
Good thing that was the one more we vote, so it's a good thing I didn't let you vote that.
Well, they've already, it's already in there.
One question that I would have, Mr. Scher, is that, you know, as I understood the testimony from the motion argument, as I said before, your client built the sign at 65 feet, apparently by accident. It appears to be a good faith accident. It wasn't something that was intentionally done, if we accept the representation there. And that what was sought to be done was just simply to rebuild what was there. If that is the case, is your client now looking to build a 75-foot sign, or are they looking to build a 65-foot sign?
What the relief we've asked for today is that as Ms. Burns said, it's up to this board to confirm the 65-foot sign. It exists in the field, so it makes sense as a logical step to say, okay, before the BMZA now, please confirm the 65-foot sign, and let us go up to 75 feet. Yes, we would prefer to do a 75-foot sign and replace exactly what is there. And indeed, as Mr. Himmelrich testified, at some point in the process, he tried to submit a permit to say, okay, didn't realize it was 75 feet, we really messed this up, we'll go to 75 feet. So we're perfectly content to go to 75 feet if indeed anticipate doing so, if given the relief that we see from the board.
Okay. And I think that there's, together with your request, you're also seeking, I guess, the other step, or you're saving on that, of having that be a LED sign?
Yes.
Or are you, okay, so you're looking for a 75-foot LED sign?
Correct.
One sign.
One sign, yes, and I think that I guess that's one point to bring out, that as I understand it, there was some issue with the community association on that point, and there was a compromise that had been reached or something like that?
Correct, Your Honor. We actually have a letter of support from the community association.
Okay. And
oh, it's in the file.
Community guy.
yeah, and Mr. French, I'm remembering that we never asked for where the planning department was in all of this. And Mr. Woolman, I haven't completely forgotten about you. Yes, although we are rapidly running out of time.
Very well, thank you. The planning department noted that the application called for electronic changing sign, I believe was the terminology that was used in the handwritten application version. And therefore, the planning department interpreted that to mean changeable copy. digital sign. On that basis, the department is recommending that if approval of this should be given, that there be specific conditions required. First, that there will be no increase in the height or the size of the sign. Second, that the entire face of the existing south-facing billboard or general advertising sign is approved for alteration to a digital screen, and that this alteration may be installed in incremental steps at the appellant's option without the need for further land use approval, so long as the billboard adheres to the operational limits or other conditions that may be imposed by the board. Third, that the performance of the digital screen billboard conform to all the requirements of Section 11-502 by having a minimum dwell time of 10 seconds, dwell time meaning the amount of time allowed for display of a single message before it changes to something different, that it will not increase the degree of illumination, and that it will not have any flashing, blinking, fluctuating, or otherwise animated light. Fourth, that the digital screen billboard will not have animations, movie clips, and/or sound elements. Fifth, that the digital screen will default to black entirely in the event of a failure of the remote control system or an interruption of advertising copy, meaning text, images, or both. And sixth, that the digital sign will have automatic brightness controls so that the sign will not constitute a hazard to passing motorists at night or during inclement weather. Thank you.
Mr. French, in your reference to height, was that the 75-foot height we're talking about here, or the 65-foot height that's existing?
We have been working from the same information that everybody else has here. So the planning department is not taking a position on whether it was 65 or 75 in this memorandum.
All right. And Mr. French, Ms. Byrne had said that there might be some concern about the lowering of the height could possibly bring any distracting features closer to drivers on the highway. With that being the case, does the planning department have a feeling one way or the other as to whether 65 or 75 feet is desirable, or as to the broader question of whether the degree of distraction is raised significantly enough by lowering it 10 feet that it's a concern, or do they think that it's not a concern if you lower it 10 feet?
At the time that the planning department first had to consider LED sign conversions in general, we researched information from the Federal Highway Administration and from a number of state highway administration sources, and we could not find any information that would allow us to make a competent answer to that question, quite frankly.
Mr. Chair, if the sign goes up to 75 feet, that it will, you're not taking the bottom of the sign and moving it up 10 feet. You're going to be increasing the square footage of the sign. Is that correct? No.
I don't think that they can do that.
Form of an extension of the pole. What would happen?
Okay, I understand. Okay, I wasn't sure how you're going to accomplish it. Okay, so you're just moving the
cylindrical
okay,
pole insert.
like a sleeve. Yeah. Okay.
So we will comply with the 249.99X that will only be 14 by 48.
Okay, that was my question.
And all we're going to do is make it, or if approved, we'll make it LED.
Okay. And Mr. Woolman, you had some examination you wanted of,
Sure.
again, I think it would be Mr. Veal.
Thank you, Mr. Chairman. Ms.
Just
Byrne.
as a point of reference, members of the board are going to have to start departing soon, so 5 to 10 minutes.
Okay.
Please.
Talk fast anyway, but I'll try to talk faster. Ms. Byrne, it's already been introduced into evidence. There was an online permit that
Mr. Veal,
eventually was discovered. I'm sorry,
I think you wanted to ask me questions.
Oh.
You're an attorney.
I am an attorney, but I do stuff other than,
Yeah.
so,
just
mean,
as we hid with
Right.
Mr. Scher, I think that questions should be directed more towards, since Mr. Veal has been sworn in, questions should be directed towards him.
Very well. Mr. Veal, are you familiar with the online permit that's already been introduced into evidence?
Yes.
As the building official, or the zoning administrator, excuse me, can someone pull an online permit for a digital billboard?
Yes.
They can pull an online permit for a digital billboard without going to the zoning board?
Well, they could pull a permit for a sign, for a change to an existing billboard sign, and you could go to the zoning board.
Okay. And this online permit application was pulled prior to the zoning board having heard this case, correct?
That's correct.
And you're familiar with the revocation letter that was eventually submitted by Ms. Byrne?
Yes.
And again, for the record, Mr. Chairman, I would frankly would prefer to ask Ms. Byrne about her letter, but if the board has directed me to ask Mr. Veal, I'll just state that for the record, that I'll
Understood, I know.
do as you see fit, but.
I think if you can first ask Mr. Veal about any input or insights he can bring to the letter, and if not, then we can.
Very well, let me back up real quick. Mr. Veal, my clients and I came to you after we discovered this online permit for digital, correct?
Yes,
So
you did.
I object to keep referring to an online sign for digital. As my client has explained, it wasn't an online, there's no digital use of that sign. What in fact it was is that there was a bolt that allowed the sign to become digital in the future. So I
And
just
I
want to point out that Mr. Wallman keeps saying the digital sign. It wasn't a digital sign. That testimony's been done ad nauseum.
And I understand your concern over the characterization of the facts here. It's understood what was built. I don't think that there's a claim that what was built was a digital sign. So that's understood.
That understood.
So again, my clients and myself came to your office when we discovered the existence of this online permit application, correct?
That's correct.
And we had you pull the plans for the permit at that time. Do you recall that? And you recall that when we noted the digital reference on the plans that we expressed concern at that point, correct?
That is correct.
And did the zoning administrator and Ms. Byrne's office provide Mr. Himmerich and his team opportunities to correct problems with the plans that had been submitted for this permit?
Yes, we did.
And are you aware of how many times the corrections were attempted by Mr. Himmerich's team?
I don't remember.
Are you aware of whether they ever pulled a demolition permit?
No.
They did not, correct?
That's correct.
And a revocation letter was eventually sent by Ms. Byrne's office, correct? And that's been introduced into evidence. And then a January 22nd letter was sent by Ms. Byrne to the zoning board. Are you familiar with that letter, the first letter that was sent regarding a sentence, the city's position that the revocation impacts the existence of the non-conforming use upon which the conversion hearing scheduled for Tuesday, January 27th is based? Are you familiar with that letter? Actually, Ms. Byrne's handing it to you.
Yes, I'm familiar with this.
Do you have any testimony regarding the meaning of that sentence, the city's position that the revocation impacts the existence of the non-conforming use upon which the conversion hearing is scheduled for Tuesday, January 27th is based?
My understanding, and I'll have to read that statement again.
Sure, take your time.
Right. So your question again, I'm sorry.
I would like to hear from you as the zoning administrator, your testimony regarding the letter, the sentence in the letter, the city's position that the revocation impacts, it's the city's position that the revocation impacts the existence of the non-conforming use upon which the conversion hearing scheduled for Tuesday, January 27th is based.
Well, to the extent that the witness has knowledge of the city's position, I think that that's relevant.
I believe it says what it says, that the city's position is that the revocation impacts the existence of the non-conforming use upon which the conversion hearing scheduled for is based.
Isn't it true that this letter was sent to the zoning board to let the zoning board know that the city's position is the existence of the non-conforming use has been impacted, and that affects the ability of this matter to go forward?
Objection.
I wouldn't characterize it that way.
The letter speaks for itself. Ms. Byrne wrote the letter, not Mr. Veal.
Overruled.
And on February 27th, there was a second letter sent, again from Ms. Byrne's office, to the zoning board that clarified further the reasons behind the revocation. I guess I'll have to pull that out. I have it as well.
Yeah, I have it here. That was the February 27th letter?
Yes.
Yeah.
Right. I'll refer you to one sentence. refer you to the second page of the letter in this last sentence of the second paragraph. Could you read that sentence to the board, please?
The last sentence?
Yes.
For this and other reasons related to construction, the permit was revoked.
So there are other reasons in addition to this height discrepancy that the permit was revoked, correct?
Based on the statement here, there's an indication, yes.
Are you familiar with issues surrounding the multiple attempts to submit plans to rectify the errors in the original online permit application? Are you familiar with any of those?
No.
Okay. Nothing further from Mr. Veal.
And Mr. Veal, do you have any understanding as to how the revocation, or the city's understanding as to how the revocation of the permit would impact the existence of the use as identified in Ms. Burns' letter?
Good question. The revocation of the permit is, I think, and Katie, I guess, can back me up on this. And the revocation of this permit is basically us saying that the permit that was applied for had some discrepancies in it in terms of the height of the sign that we believe rendered that permit not valid in the extent that we could allow in that it allows you to put back what was there before. It's not what was there before. It wasn't 65 feet high, it was 75 feet. And so that issue obviously is subject to appeal. In addition to that, there's a pending appeal to add LED to the sign, and all those issues regarding ownership and all of that is something that I'm sure the board's going to have to deal with. But we don't believe that the revocation of the permit necessarily terminates the use. It just allows, we're just noting that, just for the record, the sign that we gave you a permit to erect, it's not correct in that the height is not the same as what was there before.
Okay, so it's your understanding the city doesn't have a position one way or the other as to the continued viability of the use?
No.
Okay.
That's a decision I think the board needs to make. We don't have a dog in that fight.
Okay. All right. And Mr. Woolman, I believe you said you concluded with Mr. Veal?
Yes, that's correct.
Okay. Sir, if you can identify yourself for the record, please. If you can speak into the microphone. Okay, are you here on behalf of an organization or yourself? Okay. And what would you like to say as to these issues, sir?
Of this area is a mix that when it was first built, the people lived right there and walked to their jobs, and now over the years, 100 years, it's changed. Not for the good as far as the neighborhood goes. With the, if you come down 83 heading south toward Mr. Himmelrich's property, you get a digital billboard right there where he built Loyola Stadium. There's a digital billboard there. It's double-sided, and it was originally one. Now it's 6. And that, you get 6 different advertisings on one billboard now, where before it was just one. Then you travel down a little farther on that same property, Mr. Cohen's property, Clipper Mill Industrial Park. He has a couple billboards right on his wall.
Respectfully, did you have concerns about this particular billboard?
Yeah, safety issue.
Safety as far as drivers on the highway?
Right. Yeah, we put up with a lot of accidents along our route.
That's the elevated portion of the highway, correct?
Yeah, over top the Jones Falls stream.
Mm-hmm.
And then there's Mr. Hemlich has a sign, Meadow Mill fluorescent sign. And then he has a sign advertising office space for rent. Then he has another sign on the property advertising Meadow Mill Athletic Club. And then he has the billboard sign along that stretch. And there's signs on the other side of the expressway that are double-sided. The Union, there's one right across from the Loyola complex, and there's one. What I'm getting at is it's like enough's enough already, you know? Enough's enough. And a lot of accidents happen, well, they happen all the time, mostly on the weekends. I guess people go down Fells Point and down the city, and they get, you know, feeling good, and they come up the expressway, and it's all this lights, and, you know, they're getting distracted, I guess. They're drunk. They have a lot of accidents. I hear them first. I hear the screeching of the, you know, tires, and then I hear a boom hitting the Jersey wall. And then we listen to about 5 or 6, you know, a couple ambulances, a couple fire trucks coming, sirens, you know, 2, 1, 2, 3 o'clock on the morning, on weekends, and off and on during the week. And it seems like everybody's making out here, but the people actually living there. And this particular billboard that they're arguing about now, we hired a lawyer, John Murphy, and we fought it all the way down to Annapolis when Mr. Himmelrich was first erecting it, and we lost. And then now they're going to put, you know, another, you know, double-sided. I talked to Mr. Himmelrich. He says he's not going to put a.
Yes, as I understand it, it's a single-sided.
He's going to supposedly put a single-sided, you know, facing north.
That is away from the community.
But it's like before, we've dealt with a lot of different activities in the neighborhood, and it's like first they come in all, you know, wine and roses and feeding us and entertaining us, and once they get there and they're there for a couple of years, it's like it gives, you know, 1 year something happens, next year it's something else. It just keeps getting, you know, worse and worse. And I watched the channel on cable channel a lot, channel 25, and on other neighborhoods in the city, like Remington, Hamden, Reservoir Hill, and it's all when they're going to build something there, the business people come in and they try to work it out so everybody's happy. I don't know who. I talked to Councilman Mersby, I talked to Councilwoman Conaway. I've been involved in the community since, well, I've known Sam for 25, since he first came to our meeting and said, it was Inland Leedy, you still with Inland Leedy, or is that something else? Still. And the people in the community were concerned about the chemicals, and Mr. Himmelrich, you know, thought they were going to be well stored and taken care of because of the flooding in the falls, you know. But it seems like they get their foot in the door, and it's like it turns into like whatever can make the most money. It's what happens, and they're like a absentee landlord thing.
I will have to ask you to wrap up your comments.
But the safety thing, the aesthetics, the environment, and we've fought every billboard up and down. They're all, I think there's like 24 of them, and we lost every one. Maybe we can work on something where the planning department or somebody can come out and hire an environmental architect and see if they can't put some kind of buffer zone around, you know, plant trees. They come in, the BG&E chop down a lot of trees along Clipper Mill Road south of Mr. Himmelrich's. We need, I mean, and they look at the park, people will say, look at the beautiful park. What do you mean you need trees? What's all? I don't know how many cars go up and down 83, you know, in a month or whatever, but they're emitting a lot of noise and a lot of pollution, and the trees help to combat that. When they redid 83 in 1990, they chopped down a lot of trees along the falls and put in gabions. And when they did that, you could hear, I used to walk my dog, and before and after, and you hear the roar coming from the, you know, from the expressway. And then our concern is too, we wanted to put, I talked to the Department of Transportation about putting some kind of a sound wall, similar to what they have down at the stadiums that hooks onto the Jersey wall. And they said they can't, they won't do it because it will block this, you know, the view of the billboards. So 75 feet would probably be good because it would be up higher, and then just keep it, I have a design where it just wraps around and it's soundproof, and I talked to the people that were doing 83 and 90. They also did the subway, and they put soundproofing in all the air vent going down Pennsylvania Avenue, so it would, soak up the sound. But I've talked to, I went to, the mayor's office, I've gone to my council people, I talked to a lawyer, he said, talk to your council people, it's a lot cheaper, talk to them, I don't get any reply, any response from them. Like I come here, while I'm waiting for other people, getting my turn to testify, I see, other council people here, they know, I don't know, I'm just a working guy, but they know I don't know the laws, but the council people help, they're like the ombudsman. We don't have our area doesn't have an ombudsman. And it's always, we've been through a lot of council people going back, all the way back to Tom Waxter and Ricky Spector and all that crew.
Okay.
Sheila Dixon, to,
At this point, I think that we've heard enough about your concerns
I'm
regarding
finished.
the
Yeah, I'm
project.
done.
As I understand it, you're concerned about the, as you said, the aesthetics and the any distraction of drivers and the safety for the surrounding community below, as well as just simple screening from the glare that may be created from the sign. But I thank you for your participation in that.
Yeah,
and sorry
just
that
say one
it's
little
been a
quick-
while.
quick
We
thing.
really do, sir. I am overdue actually to leave. We have other members who are going to need to leave imminently. We've been hearing this matter for like almost the last 3 hours.
Well, maybe you can just direct me in the right direction. Who do I talk, it's like bulk trash everywhere from the apartment
That
houses.
issue I can't give you advice on.
Pardon me?
I said I can't give you advice on that issue. You have to find that one out on your own. Okay. All right. And Mr. Scher?
My sense of the bottom line, the practical bottom line, is that, as Mr. Veal or Ms. Byrne testified, that they're revoked because the VMZA has to make the decision as to whether it should be 75 or 65 feet. So whether or not that's the case, and whether or not we agree with that because under 11502, we're talking about decreases, and because the original approval from 24999X said you could go no higher than 75 feet. So whether or not that's the case, the fact is that this board can approve what is currently in the field as a static sign, and then allow us to use that as a base to raise the sign to 75 feet, which we actually seek or sought to do.
Are you saying that we can do that if we uphold the revocation? Are you saying that that the board can deny the revocation and recognize the sign, or do you mean either way?
You can, yes, and you can do it either way. You can say, well, okay, maybe the city's right, maybe we should revoke it, but only because it's our decision, so we make the decision to approve the 65 feet in static sign. Or you can say, we reject it because it was a good faith attempt to try to go to 65. It was set to the height that they thought was a legitimate height, and it didn't work out. But it's irrelevant, because today we're going to be making a decision as to whether or not the static sign is sufficient and can be used as a basis to raise the sign to 75 feet. In other words, we don't want to take down the static sign and then put up a hole in the pole. What we're going to do is put an extension on the pole and put up a 14 by 48. We'll keep the 14 by 48.
Incidentally, these signs, and I want to address the Bolton issue, they're all amazingly similar. Every one of the signs, the original sign, the second sign, they all started 42 inches in diameter.
Well, I'm not sure that that aspect of it, the nuts and bolts aspect of it, I think that that's more of a building code issue, which I don't see as part of this case. I don't think that we've got the jurisdiction to interpret the building code. But I do take your your position there regarding the relative indistinguishable nature of the various fastenings and the way that that can be accomplished. I'm just not sure that that's an issue that we necessarily need to resolve in this case. Okay. And Mr. Woolman, were there any concluding remarks?
Yes, Mr. Chairman, and the reason why I asked Mr. Veal about the sentence, I would have preferred to ask Ms. Byrne, but the sentence in the letter regarding other reasons related to construction is to make the simple point that we're talking about more than just a height discrepancy here. There's a whole second half to this revocation that's scheduled before administrative law judge. If the board does choose, again, I would rest my argument on Ms. Byrne's statement at the beginning of the day, and that is today there's no legal sign out there. I don't see how this board has the authority to approve a change to
Well,
existing
she also
sign.
pointed out that, that there was a permit that was lawfully issued, although it's been revoked. There was a timely appeal noted and taken from that, and so the rights that the applicant would have acquired under that permit would continue pending the result of the appeal, which could include a result either upholding or rejecting the upholding or reversing the revocation, or as Mr. Scher suggests, either way, the board could address the question of the appeal in the companion case, that is 2014-64, recognize what's built there and use that as basis to move forward. And I believe I understood Ms. Byrne and Mr. Veal to say that the city had no position one way or the other as far as how that gets handled.
But I certainly would submit to the board that if the board does choose to approve anything here today, that approval be conditioned on the revocation being denied in front of the administrative law judge, because otherwise the board would be ruling that a change to an existing sign can be made, but that sign is found to have been properly revoked by administrative law judge
Well,
on the other
I don't know
issues.
what is or isn't pending in front of an administrative law judge. I do know that the issue that's before us in 2015-25 is the question of the propriety of the revocation. So we have to resolve that. I would think that would make moot any other proceedings regarding that. I think that we have jurisdiction there. And you know, we move forward from that point.
The only other statement I would make, that there's a lot of back and forth about innocent mistakes going to 65 feet, et cetera, that any question as to that issue could have been resolved if Clear Channel's sign were allowed to remain up during its lease and a field measurement was made. I would make that point. Again, that's an argument that we're resting a lot on, that this sign should not have been taken down when it was, and when it was taken down, the non-conforming use was abandoned. And with that, I'll submit.
Okay, thank you. Thank you all.
I can make the rest of this hearing. Oh, you're gonna retire. Okay. I know it's getting late, so I was just gonna say I can make the rest of this go quickly. Mr. Wallman said that he doesn't object to relief of the sign. I mean, if we get past these issues, doesn't object to a digital sign, he's not going to oppose that. So we can almost do the rest of that by stipulation. And then I have Mr. Guckert here who will testify as to the safety of the signs and testimony presentation. In a very short testimony. I just, in terms of your scheduling, I want you to know that I can make it quick.
I think that we can address those issues on what we've got in front of us. I'm not sure that there's a need for further testimony. Okay. Thank you all.
Thank you.
And we're off the record. Okay. I'm 24.
I did about a 180, and I think as I listened to Ern speak, she's right. I mean, I think that, at least I think she's right, that it should go to us, because nuts and bolts are one thing, but, you know, bigger, smaller, how does that impact? That's more subjective, and I think that's more of an us type of a decision.
Trying to put myself
think that a change had to report some sort of impact study kind of expert testimony. So there's got to be some significance to 75 and 65
Right.
in terms of impact. I would think that that was what they were getting at in terms of saying that, it's got to be identical, otherwise it's going to come before us.
And that's where we come in.
I kind of feel like the language in the 99 permit that said limited to 75, because they built in 65, they're within the limits of the 99 permit. And then the code says that you can't increase the height of signs. They haven't done that. So I feel like, personally, I think that it was revoked in error.
You know, that's where I started from, but the more I listened to Jeff and Kathleen Byrne talk, the more I became convinced that, okay, so it's smaller, but it may be different. Maybe smaller is not better, or maybe you can't. I bet you can't say, okay, 75 is okay, 65 would certainly be encompassed with a 75, so it's not bad. But I think I sort of did on 180. Say, well, maybe there's more of a problem with a 65 than a 75, and that's where I think we come in and have to make your testimony and make a judgment as to does this work.
I think that from the standpoint of the inspector of appeals, or even the zoning administrator's office, from their presentation, I had more appreciation for that side of it, that it can feel like whether it's the zoning administrator or the inspector, feels that they are exposed to making those kinds of determinations. Those are determinations that they then say, well, if you want to do this, even if I may think that it's simple and straightforward, that's something we should go to the board for. And they view that even if it's to the effect of minimizing their authority, it seems as though they view those kinds of decisions as something that they'll defer to us on. Now,
As opposed to like using a 3-inch piece of steel where they should have used a 4-inch piece of steel. That's them. That's nuts and bolts.
Right. And now I think that the effect of that is just simply that the decision as to whether or not the permit gets issued is just simply one that goes to us. I'm not sure that the revocation of the permit with a timely appeal taken has a substantive effect on the outcome. If the board is just simply able to, at the end of the day, determine the question and say that, okay, well, if yes, this isn't something that the zoning administrator can do, but the board can do. And I think it's a little bit sort of circular too, that what was built was a 65-foot sign. It was intended to replace the 75-foot. It was a 65 feet in error. They want to put it at 75 feet. So at the end of the day, we're making a decision and issuing a decision to approve what the zoning administrator could have approved if it was properly documented at the beginning, which is a 75-foot sign with the same dimensions and all that. Now, there's an added aspect of the LED, conversion of LED. Those, we typically even handle those on a consent basis. The planning department issued their standard conditions, and there's not objection to those. And with the restriction on it being a single phase versus double phase sign, I think that includes the community concerns. As I understand, that was something that was reached with the input for the community association. So I'd be in favor of a sign at 75 feet, LED sign, subject to the conditions offered by the planning department.
I agree. I think we need to say that I believe that the
permit was properly revoked.
Yes, and added to that, yes, I would uphold the revocation.
But the facts and circumstances are, I don't view that as something that impacts negatively on the project.
Yes. Particularly given the history of how that.
Right.
Because I think that even the city and Clear Channel didn't locate the original set of plans until sometime later.
Yeah, I'm good. But I agree with Frank that it should be included that we were upholding the revocation.
Yes,
Because
I
I
would
don't
agree.
see where the city acted in error.
Yes, I would agree. Okay.
Do you want to vote on that separately? Or
No,
do
I think we
Yeah.
can vote on it all together. Yes. Okay, all right. I am in favor of decision upholding the revocation of the permit. I will vote in favor of the application to construct a billboard, general advertising sign at 75 feet with the dimensions as originally approved in the 1999 decision. I forgot the case number. And subject to planning department conditions. Did I already say 75 feet?
Yes.
Yes. All right. Okay.
We usually don't have this kind of an audience.
Your decisions on the other cases?
Yes, and as to the other cases, okay, we just dealt with those two appeals. 2014-536, 3423 through 49 Noble Street, I'm a yes.
Yes. Yes.
And 2015-35, 1003, 1005, and 1007 South Belnord Avenue, I'm a yes to the planning department
Yes.
conditions.
Agreed.
All right. Thank you all. Now,